writ appeal in a service matter, my lord.
No mention. Because, yes.
Lord, I heard no mentioning, but may I just take one indulgence since I was to travel from outstation and today
No,
there's a part.
It can't be.
But-
It's a different bench. It can't be. Yes. Mention when the regular bench is available. Yes.
Next one, say, writ petition 38401 of 2014 and connected matters.
Yeah, for why you are this?
1.4. 1.4.
What is 1.4?
Where the IA 1 of 25.
1 point? What is 1.4?
Number 1.4.
Serial number 1.4. Okay.
1 of
29107 of 19. So that is to be, this petition is to be dismissed. This 29107 is to be dismissed.
oh, short point only concerned you.
This 29107 of 19 is to be dismissed. All right. Learned advocate.
No, dismissed, he's saying, my lord said whether it should be dismissed. He's saying whether your petition should be dismissed. No, he's asking this.
Dismissed. It is to be dismissed. Why you are mentioning 1.4?
1.4 is listed.
Dismissed.
No,
So we are going to dismiss that. That is what you are telling.
that IA filed.
IA is filed in that.
Yes.
Oh,
IA 1 of.
IA is filed.
Is they have said with the.
Where is that IA? Where is that IA? IA number?
Before that, I want.
IA number?
IA 1 of.
1 of? Where is that IA? 1 of 25. Same.
Filed on 18th March.
18th March. Yes, 18th March. So this IA is containing of 4 paragraphs. So you are sending the court a telegram or you are filing IA? This is a telegram sent to the court or you are filing some good IA with pleadings? This is a telegram sent to the court. We don't appreciate such a cursory filing of the IA and such a useless pleadings. Is it a telegram sending to the court or you are filing a court pleadings? There is no affidavit, nothing. Affidavit is there, but four paragraphs. What kind of pleading you are making? And it's assembling the bench, wasting the court's time. What is it now? Proceed. This is no way of pleading with the High Court in a PIL. This is just sending a telegram to the High Court.
That application you will not, paragraph 4 you will not.
What is it now? Tell us.
Prior to that, para 3 you will.
Yes.
Petitioner will submit that newspaper account last updated on 18th March. So reported that a program called.
We don't rely on any.
And prepared has already placed in.
We don't rely on newspaper.
My full submission last NDC. There is an order passed by this Honorable Court on 14th March 2000.
So what is the difficulty?
My writ petition.
What is the difficulty now?
The permanent structures have been put up
Oh.
inside the upper zone, like
Oh.
that area. It is contrary to section 12(3) of the Karnataka Tag Conservation Development Authority Act.
So there is nothing,
Support
nothing,
of that, I make
no
that-
plead,
I
no,
pass on this
no pleading,
for a moment.
no pleading.
Disclosure. No.
Very,
One thing I'm making very clear. We are not against already RT being.
we are saying there is no pleading. There is no pleading. We don't know who is, we don't know about from Mr. Counsel, there is no sufficient pleading. He is not able to.
Yeah, I have mentioned the section of the Tank Development Authority Act, I represent the provisions. Provisions of para 3, Karnataka Tank Development Conservation Authority Act.
Which
That with the program. In the-
violation of Article 50A? What is that 50A?
What is that?
Which is Article 50?
Para 3.
You are saying that violation of Article 50 capital A.
Cross violation of the provisions of the. Karnataka-
What is that violation? What is that violation? What is that violation?
58. Question is.
What is the violation? You answer, otherwise I will not proceed. What is the violation? What is the violation? No question. What is the violation?
Permanent structure.
So what is violated?
Yeah, for not to put up.
What is violated?
What is that?
He's not able to, they're able to listen. Ear problem.
Kindly see, to consume immense disturbance to the birds housed in water body, and this would be in violation of, because they put up all structure, which is temporary and permanent, conflict with the order of this allotment. That's my prayer. So, hence, to stop all construction activities temporary, permanent, or otherwise, and remove all construction and directions already done from the buffer zone of the Sankey Tank Lake body immediately in intercept.
Ask them to close the door.
Sankey Tank Lake body.
Yes.
Sankey Tank Lake body. It's my prayer. In support of, I felt that I may
So-
permit to pass on this.
What law is violated?
Violation is that permanent structures have been.
Which law is violated? Which law is? Madam, you just assist the council. Yes,
Yes, sorry.
or
Apologies.
the junior colleague sitting behind. Madam, you assist because he has some ear problem. What's your good name? You just assist. We are asking him what law is violated. Just there.
That is a violation of the protocol.
In fact, if I can just assist, if my lord's wishes,
Yes.
under the provisions of the
You're
Tank Conservation and Development Authority
Yes.
Act,
You are also appearing.
I'm appearing not in my friend's matter. I'm in serial number 1, which is the lead matter,
Lead.
not in this matter.
So last look into the photograph. The first photograph you last me. It is inside the lake, the construction has been put up, your lordship. Inside the lake, construction has been put up. And then DJ sets have been kept here. Then next photograph, your lordship may kindly see the high mast.
ಏನದು
It is done by BBM.
Yes,
Who is
Yes.
doing it?
yes, yes. sir.
BBMP. Anybody appears
No,
for?
I'm also pleased to pass on the coordinate bench order in this matter itself, your lordship, where the specifically it is stated that you can't. Kindly, I'll pass on, because based on that, the content was also ensured and they in there, your lordship.
Who is organizing this event?
Yes, sir.
Who is organizing? Who is organizing this event?
My lord, this,
By BWSSB, Bangalore Water Supply and Sewerage Board.
Who appears?
My lord, I appear for BWSSB.
So your
Copy is also not furnished, my lord. IA copy not furnished. What he is giving to your lords is not furnished. Nothing is furnished, my lord. I don't know. This is the way.
In
my
my,
lord, it is
in my petition,
form.
lordship may kindly see,
I don't
it is only BBMP.
you are organizing this event. You
No, no.
give copy, at least give copy. At least otherwise there is no point in hearing.
I'll give you. BBMP is a party in my writ petition, lordship.
Who is organizing the event?
No, I can give the pass on this copy. No, my responsibility, kindly see the order, your lordship. No, my responsibility is that we are not against any Aarti, Kaveri Aarti or Ganga Aarti being performed in the water body lake. The puja also can be performed. The question is, they can't put up any structures
and
under
then
the guise of this program and destroy the water body, and it also affects the night life of the bird because high mast lights have been put up, your lordship. And in fact, in this also, your lordship may, the direction, your lordship will find at paragraph 15,
Copy has
1
been put
point
up.
in that order also.
Don't know.
So you are organizing some Aarti.
My lord, I'm not organizing any market. My lord, we are having
Some
Aarti, my lord. That's all. In fact, my lord, application not given. What your lords is, my lord, today, my lord, given, that also copy is not given. And my lord, we are asked, my lord, like, it's like, my lord, running a race with our hands and put, my lord, tight. I don't know. I can only say this. This is, my lord, after obtaining all permissions and sanctions in terms of, my lord, the,
So you are Lake Development Authority.
my lord, I am the, my lord, BWS, Water Supply on the Sewerage Board. We have taken permission from the Lake Development Authority. We have taken permission, my lord, from the BWS, BESCOM. We have taken, my lord, permission from all authorities.
BBMP also.
BBMP.
And conditions have been imposed while granting for doing this event also, my lords.
You are
14
there.
conditions. 14 conditions have been
Advocate
put.
General is.
You are there, Mr. Advocate General.
Please, well, online, well, I'm sorry, well, I had to come
On
Delhi
whose, on whose behalf?
state government's behalf, my lords.
So
My
what
lords,
is
it has been done strictly in accordance with law, my lords. Conditions have been imposed, time restrictions have been maintained, Lake Development Authority permission has been obtained. And it is awareness of water and water bodies, conservation of that, my lords. And this is there, my lord. Tomorrow is the function, day after, my lord. They come in the last moment, my lords, without verifying whether we have obtained doing it in accordance with law or not. All precautions have been taken by us, my lords.
But what you are going to do exactly?
My lord, this is only for puja which is being going to be done, my lord, and the awareness of saving
Any
water and
occasion?
water.
My lord, what? I tell your lordships, this, my lord, tank, there is, my lord, puja conducted for the last 100 years. This was, my lord, the very, my lord, genesis of, my lord, some of the tributaries of Kaveri. This was, my lord.
No, any occasion is
May
there.
permit me to say what I want to say, please?
Please.
Any occasion is there.
My lord, water day, my lord.
Water.
Yes, my lord. We'll have to, my lord, ultimately, my lord, we will have to make awareness to all the people. My lord, today, we are, my lord, in the thick of summer. I can tell you, lords, today morning, I came late because, my lord, there was no water in my house. This is where, my lord, we are. We'll have to, my lord, create awareness. And that's what, my lord, we are trying to do, my lord, with this. Whole idea, my lord, is to create awareness amongst the people. We have taken permission from, my lord, BWSSB. We have taken permission from Lake Development Authority. We have taken, my lord, permission from BBMP, BESCOM, everybody. State government itself, my lord, is sponsoring. In fact, my lord, the respondent before your, my lord, the petitioner before your lords is herself, my lord, conducted several programs on the lake.
But you are not a party even.
I'm not even a party, my lord. I'm not even served, my lord.
In this matter, it's a separate petition filed wherein the BW.
In this IA, your PWD,
I'm BWSSB.
not a party.
What
No, Lordship may kindly see the writ petition, Lordship. For a moment,
No,
my
we
writ
not-
petition.
No, we are.
In that, BBMP is the custodian of lake, Your Lordship. BBMP is the custodian of lake.
Mr. Council, event is organized by PWD. If you are willing to join the party, you can join. Otherwise, we are going to dismiss on that ground only.
No, my only response submission, Your Lordship.
We will not hear it. This can't be in a cursory way
No,
and holding the time of the court by filing such a frivolous petition.
No,
in terms of the pleadings at least, if
no,
not
Your Lordship
subject,
may kindly
if
see.
not subject matter.
BWS.
Absolutely cursory way of
No, BWS
throwing
is
the,
not.
throwing,
No, Your
throwing
Lordship may
the IA
kindly
to the
see.
court. You're just throwing the IA to the court.
No, I am not on that, Your Lordship. I am making.
We are on that.
BWSB is
Kindly listen. If you are not able to listen, ask your colleague that what court is expressing. This is a very cursory way of throwing IA without sufficient pleading, like anything, and wasting the time of the court.
I'll file an
And you are
appeal.
not joining even a party who is organizing the event.
No, the question is, may make submission. My
It's not a
case,
panchayat.
no, my
This is
case
court
is
of
against,
law.
no, my case
This
is
is first
against
court.
the
You can't submit a grievance in this fashion.
BBMP, against BBMP and the government, Your Lordship. The authorities are, Karnataka Time Development Authority also implementing application is filed. That is also pending before the Supreme Court in this matter. And orders have been passed on 14th March
It is an
2023.
informal panchayat
No, my only
of the
response.
leaders of the town.
No, I am
Sit
not.
together and listen the
I am not against anything what they are performing, Your Lordship. Only thing is they can't organize leisure shows and other things. That's all. Leisure shows will affect the nightlife of the birds. That's all I want to. Limited, they can do it. We are not against performing all.
Where is the prayers in the writ petition? Where is the prayers?
Good afternoon.
You are not able to listen what we are expressing. Then what is the use of it? You hand over your writ to somebody else.
Because
We passed the order and you don't understand.
no, my writ petition prayer also.
It will also breach of natural justice.
No, in that, Your Lordship may kindly see, BBMP is the custodian of lake. Annexure D, for a kindly moment, look into this, page 43 of my writ petition.
Page
43, Annexure D.
40.
The BBMP are the custody of lakes, Your Lordship. 168 lakes in BB, page 43, Your Lordship.
Yes, 43. Let us see. In the main petition.
Page 43, Your Lordship.
Page 14.
43, Your Lordship. Annexure D.
Yes.
This is filed by BBMP in the correct. 168 lakes, Your Lordship. Total 168 lakes being in the custody of BBMP. Then Your Lordship may kindly see list of lakes, Your Lordship. In that, the Sagitek is also mentioned, Your Lordship. This is one of the part of the lake. So my only response, even in the R.R. Nagar, Malatali Lake was there. This was the subject matter in earlier IA which was filed by me. Then this Honorable Court directed on 14th March, for any reason, you can't conduct any programs, rituals or whatever it is there, to destroy the lake and water body within the lake bed area. We are only concerned on that lake bed area. They can't put up any structures which photographs. They can conduct the puja and other things. There is no problem at all. We are not against all those things. You know. The only thing is leisure go they are doing it. And lightings, high mast lights have been put up by virtue of it. And also procession of 10,000 people, they go in a procession inside. And fully entire area, lake area is being put up with all the structures. You know, and also inside welding is going on. Kindly produce the photograph. So these are things we are, which is contrary to section 12(3) of the Karnataka Tank Conservation Development Study. That's our submission only for that limited purpose. Section. The Karnataka Tank Conservation and Development Authority Act, section 12, Your Lordship, may read. Acts prohibited, Your Lordship, but notwithstanding anything to the contrary contained in any law for time being imposed, no person or institution or organization or company or firm, association, government department, because this is also part of it, corporation or any local bodies or authority and other, on there we have shall. So 12(3), Your Lordship, subclass 3, Your Lordship. Make any construction or carry on commercial or recreation or industrial within the 30 meters from the outer boundary of the tanks. So this construction which we are concerned about is the permanent structure inside the tank area. 30 meters buffer zone they have to maintain. That's all we want. They can have the program.
You're permitting the permanent construction.
There's no permanent structures, my lord.
Nothing, my lord. That's an incorrect statement is being made, my lord. No, we will not, my lord. Your Lordship may record a statement. Permanent structure. Well, why will we construct permanent in the lake, my lord? It's in violation of law. My learned friend is incorrect statement is being made. No, my lord.
You are not also permitting any market stalls. No. No selling of the.
No.
Selling of the. No selling of toys or sweets.
Nothing.
Nothing, my lord. My lord, there's no pleading. If we had to file a separate writ petition, challenge pleadings, we'll be able to answer.
No idli, no pani.
Only if my learned friend Mohan comes, my lord, we'll serve him, my lord.
Separately, my lord, we'll serve it by hand to him. That's all.
So no construction. No construction, no stalls, no markets.
Your Lordship may record it, my lord.
No pani puri.
No.
No. Pav Bhaji is available in Bangalore or not?
Very much, my lord.
Okay. So you are not even here.
The only thing is the Lordship, they can't use the
This is
leisure
abuse
shows
of
and
process, my
lights.
lord.
That's all we are concerned on that, which affects the nightlife. That's what we, even in the photograph which I produced, past them. So, and if your lordship look into it, they are using a music DJ set, your lordship, which high, even in the connected matter, your lordship may this,
They are
this,
playing music.
may pass on this also, your lordship. In the contempt matter, they afforded, because in Malathi Lake, they wanted to use it as an amphitheater, may pass on this, sir.
Play music very high.
Yes, my lord.
Your lordship may pass on the order of this arm court in contempt matter, your lordship.
There is nothing.
No,
This
they
is
can't.
not the- this
No,
is
no,
not-
what happened? Well, 14th March,
We can-
why
we
the
can
order
only-
is passed?
Can only ensure that there will be no breach of section 12.
Kindly,
do that.
maybe just pass on this order for a moment.
We can't go beyond, this is not the subject matter of court. RPA.
In that also, Lakshmi, they wanted to use that area for every year, Shivratri program and other things. The petition was filed and the order was passed by the order 14th March 2023. That has been violated. Ultimately, the affidavit is filed by the Chief Commissioner BBMP. And kindly see para 3, what is reproduced at 14th March order, your lordship.
This is a contempt matter.
Yes. Then subsequently, they filed an additional affidavit on para 4. Then
Contempt.
proceeding was dropped. They said they will not use it as, only thing, this is also same thing. DJ said everything has been put up now, which is using for the purpose of a cultural, whatever it is, which is prohibited under the section 12.3. We are only concerned on that. We are not against any performing arti or puja of the water body, whatever it is. Which is within the lake bed. That's what my responsibility. Only to limited scope with their, because after all, we had about nearly 800 lakes in Bangalore worship. Now, as per this list, only 168 lakes are there now.
So, anybody wants any guess, anything? Yes,
No. Hello?
nothing.
Much happens.
And in fact, your lordship has pleased last week, two motor writ petition also there. Any order, these are all serious orders, various orders have been passed in the main matter also. It is not being followed at all.
Nothing from BBMP.
Nothing, my lord.
So we take that you accept whatever he
No,
No, my lord.
my lord, there's no, all I meant to say is
It means that
My lord, what we can say will.
so this is IA number 25. 1 of 25. Or learned advocate Mr. Mohan. What is
Yeah,
Mohan? Is senior?
no,
Mohan for the applicant, learned additional, learned advocate general Mr. Shashikant Shetty for number 1 state. Who is for number 2? 2. Who is for number 2? Mr. Advocate General 2 also you are referring.
Please, my lord. Please.
Number 1 and
I'm sorry, you will respond 1 and 2.
1 and 2 assisted by learned additional government advocate Srimati Nilofar Akbar. Learned advocate Mr.
Prashant, my lord.
Prashant for response 3. As the Commissioner, Bengaluru Mahanagapalika. Who is for Bangalore Development Authority?
Krishna.
Learned advocate so and so, number 4, the Bangalore Development Authority. Or for Pollution Control Board? Pururaj Joshi. And learned advocate Pururaj Joshi correspondent number 5, Karnataka State Pollution Control Board. The present IA filed in the proceedings of writ petition number 29107 of 19. Presented with the following pleadings. Support the entire. The prayer, though not separately made, is found in the averments in paragraph 4. comma, which is to direct the authorities, including what is BWSSB?
BWSSB, the Bangalore Water Supply.
Including the Bangalore Water Supply and Sewerage Board to stop the event described as Ganga Aarti program, which is stated to be scheduled to be conducted in the night, in the evening.
Yes, that is,
In the
your lordship, yes, inside the tank.
in the evening of
Page 45, lordship, the list of tank.
evening of 21st March 2025. At the place of Shanki, SANKY, tank, water body. Full stop. The petitioner wants, the applicant petitioner wants to stop all construction activities, temporary or permanent, at the place of event. That's the lake. It is to be noticed at the outset that though the prayer is addressed to Bangalore Water Supply and Sewerage Board, comma, it is not a party either in the main writ petition nor impleaded in the present interim application. Evidencing that the application is filed in a casual fashion. In any view, learned senior advocate Mr. Holla was present in the court at the time of hearing of the application, who represented BWSSB, full stop. A copy of the application was furnished on behalf of the petitioner.
Oh, my lord. Even now it is not served. Even now it is not served. I don't want to say anything more, my lord.
When we say it is
Please, my lord.
deemed to have been
Please, my lord.
is furnished and is apprised of the controversy. Paragraph. Furthermore, furthermore, it is to be noticed that the main contains the following prayers. Main petition, which is public interest petition, contains the following prayers. 1, to direct. To direct to the respondent, to direct. Then next, to direct to the respondent. 2, Roman small 2. And third, to direct this number 1 to constitute the paragraphs. Full stop.
And your lordship, in the annexure D, page 45, the list of tank is mentioned, custodian of BBMP, serial number 34, your lordship. Yes, lordship.
It could be well said. On bare reading of the prayer in the present interim application as well as the municipal prayer, in the petition from which the interim application arises, comma, that the prayers in the interim application in a way travel beyond the four corners of the principal prayers advanced in the petition. Full stop. However, paragraph, since this is
In the
filed as
list which I produced, list of tank,
public interest,
page 45, your lordship, serial number 34 is the Sankey tank, West Zone, Bangalore West Zone. Custody of BBMP. So that is the reason.
since it is styled as public interest petition and public
Right.
interest, comma, court relaxing the standards of examination comma, third, present interim application, comma, the content, prayers thereof. Full stop. It has to be observed that pleadings.
In fact, that lake is the one of the cleanest lake now we are having in Bangalore. Basically, it's maintained.
The interruption is there.
They, by which,
If you interrupt now,
Yes, Raj.
then we'll solve.
Please.
Hold the RP.
Yes, Raj.
Go to the lake and hold the RP. No interruption.
Please.
And the order is this way. If you observe that pleadings in the interim application are too cursory to be countenanced. Full stop. The interim application, the casually filed without prayer, laws as such, comma, looks like a telegram sent to right. Full stop. Not only that, there is no substantiation of whatever alleged in the interim application except production of some photographs and the report, comma,
A separate memo, Your Worship.
filing of application with such state of pleadings, contents has to be deprecated.
Yes.
Paragraph. In any view, comma, since the question of ecosystem surrounding the Tanki Lake, Tanki Petar water, Tanki tank water lake, water body, can in any is raised, comma, the court permitted. Don't it now the applicant makes up. The grievance is that the holding of Kaveri Aarti at the banks of the state water body, the damage, the surrounding and would further play deprive the very water body and the eco system. It was submitted that certain acts are prohibited in the tanks as per section 12 of the Karnataka Conservation and Development Authority 2014. Since the violation of the statutory provision section 12 is alleged, comma, the same may be reproduced. State's provision may be reproduced. Is reproduced here in the court section 12. When the court asked about the compliance of the provision, and the regarding carrying out the activities at the tank in the first section, comma, learned advocate general, comma, learned advocate to the BBMP and learned advocate for Bangalore Water Supply and Sewerage Board in one voice assured the court that the event proposed to be organized is The nature of it. Culturally. It is stated, it was stated that the RP is not organized for the first time, but in past also, there have been instances where such RP was organized at the very place.
Yes.
Full stop. Correct. The court further asked whether authorities are permitting permanent structure on the bank of the water body, or that they are further permitting during the event any stores for selling food or other items, etc. The answer was in emphatic negative. It was stated that the event is going to be only a cultural without any commercial approach or any commercial activity permitted to be done at the time of the event. In view of the above assurance, the court does not see any reason to pass any order in this application, except that the authorities shall, while conducting the event, ensure that the public movement, public order, and public gathering is managed to maintain the rule of law, to maintain the law and order, and further that the provisions regarding the prohibited acts in the tank and near the water body, as provided in section 12 of the Act quoted, shall be observed.
Please, my lord.
With these observations,
Even subsection 8, your lordship. Section 12, subsection 8, your lordship.
So,
subject to above.
Yes, in fact, subsection 8, your lordship, for a moment.
your lordship may say full act, my lord, not act, the whole act.
Do
is
any
not
other act which is distributed directly and indirectly to the tax. Yes.
How much cost?
See, now the-
Cost.
Now, kindly see the photograph which I produced.
Cost.
Yes, sir.
You ask them the what cost to
Section-
cost.
Section 12, subsection 8, your lordship.
See, but then after you tell us
In the act, because that also, your lordship,
subsection
apart from section 12, subsection 8, your lordship.
to do any
Do
other
any other act which is detrimental directly or indirectly to the tax. So in that, this photograph which I produced, it is inside, they are put up all the stage which is, and they are organizing
Sir,
the.
Advocate General, this will be all right. We recorded your assurance.
Please.
Definitely, my lord,
And
we are
can I
interested
also
in.
seek your lordship that
It is all right.
section
It's
5,
all right.
section
Well,
13,
we'll come.
subsection 13, please.
Section 513.
Subsection 13. Permission is granted. Encourage participation of communities and voluntary agencies in development of the tank to launch public awareness. Well, this is what we are trying to do.
Where is that?
Lord, please, section 5, subsection 13, my lord.
13.
1(3). To encourage participation of communities, voluntary agencies in development of the tank.
Which my learned advocate for Bangalore Water Supply Sewerage Board would submit that this event is on the contrary organized in order to promote and encourage the public awareness to the need and importance of water in the life and affairs of the common man.
Correct.
Full stop. We invited attention of the court to section 5, subsection 5(13), which section deals with the functions of the authority and states that one of the functions is to encourage the participation of the communities and voluntary agencies in development of tank and to launch public awareness programs for tank conservation, preservation and protection. Full stop.
But
Full stop. There is no gainsaying that in the recent times, there is always a greater need whereby the awareness about the use, conservation, and
Yes, sir.
disciplined approach
Yes, sir.
to the water bodies
Yes, sir.
and the awareness among the people in that regard needs to be disseminated and
Please.
promoted.
Even subsection
Please.
12 also, 512 also says the same thing.
This in this way, it was submitted that the event conducting of the event has to be viewed. Correct. This context.
No, even this, it speaks about how to develop and protect the tank, not to destroy by virtue of this putting a permanent obligation. Sufficient. The main matter is pending pertain to the
Matter will take up.
pertain to the CSR fund,
Main
wherein they want to have maintain the lake by the corporate bodies.
main-
So question is, when the corporate bodies are want to maintain.
Rashmi, have it on some
the-
other day, Malad. Can I request on some other
From
day?
where these BWs got the funds and want to organize this huge program by putting up such a structure, that is an issue which mainly working on my mind. That is the main intention to move them, because BW was not a party in the main petition.
even from photographs.
Only thing, we are all concerned about the nature.
Unless they
Preserve-
organize market,
Please.
these photographs
Please,
doesn't
sir.
show that any
Yes, sir.
detrimental activity.
That's public.
Main purpose. Will correct. You are in main, your party in main petition.
We are not a party.
Your party in main petition.
We are not a party. We are parties. Copy in a ceremony.
Main petition.
Your Lord.
Indulgence, mention
Your
item
Lordships.
22.
One mention. They appear for the appellants in WA 1569 of 2024. This is the matter, my lords, pertaining to the Chief Minister's challenge to the Governor's order, the MUDA issue, the MUDA writ appeals, my lords.
We do not know any chief minister or any governor.
My lords,
We never know anybody.
please, my lord, there are few writ appeals that are filed that were scheduled to be,
Chief minister and governor, we do not know any such matter.
my lords, there were 3 writ appeals that were
Or
filed.
before the High Court of Gujarat, High Court of Karnataka,
Please,
and make a proper mentioning
please.
with disciplined language, disciplined references. We do not know any chief minister or any governor.
There were
Please
3,
mention whatever you want to mention in proper way, with proper language, and knowing your bounds.
please. There were 3 writ
May be handling any matter. We are handling not such matter, any such matter, with such references.
There
Yes, Mister.
There were 3 writ appeals that were filed, my lords, challenging an order of this honorable
Yes.
court, single bench. This is a matter pertaining to the allegations in the MUDA matter. These 3 appeals, my lords, were scheduled to be listed on Saturday. But we are informed, my lords, that there's no sitting. So on a collective request, my lords, with the consent of all parties involved, we are requesting for an adjournment, my lords, to April 28th.
Very well. April 20.
With your Lordship's kind.
Inform
Lord,
me.
may I mention a matter with my Lord's indulgence? Item 22.
Yes, Mister.
Yes, my Lord, I'm sorry. I have a part head. I'm not able to come today. Your Lordships had wanted me to appear physically. Can it, subject to my Lord's convenience, can it be on 25th of March?
25th of March.
Please, my Lord.
Any urgency, then we can keep it.
Yes, my Lord.
Please, can you
Urgency
wait?
was there. It was listed today.
Ask him to wait. Things are not over for you. Please wait. Yes, you want to.
But 25th of March, it was listed today because of the urgency, but in view of a part head in the Supreme Court, I'm not able to physically come. So I'm requesting if it can be on 25th.
All at 25th March. So we'll.
Very
keep that.
deeply grateful.
Yes,
Deeply grateful.
keeping on 28.
28th of April.
3 appeals.
Please, my lord.
3 appeals.
3 appeals.
3 appeals,
With your Lordship's kind leave.
which is kept on 22nd. Councils are coming from Delhi.
Please.
So inform the office of the. You inform. You inform.
My lords, there are 3 appellants and private respondents as well as the state.
With your Lordship.
It's got, there is no chief minister, there is no governor, there is no judge, only litigant.
I apologize.
Yes.
Because the matter was listed on
Wait.
Thursday, I had to, I'm
Correct.
sorry.
With your Lordship's kind leave. Serial number 97 in today's list, my Lord. It is the matter relating to the election of the Bangalore Advocates Cooperative Society, wherein the election was held on 9/8 itself. But the results are to be declared without the permission of this court. It cannot be, my Lord. That's the reason I have filed an application for modification of the interim order to permit the declaration of the results. It may kindly be taken up at 2:30, my Lord.
There is no urgency, we'll take up.
My Lord, already the elections are over. The results are to be declared, my Lord.
Not, we'll take up, but not out of term. We'll take up.
A term, if the term is completed and the petition becomes infructuous, my
When-
Lord,
when
that's the
the-
reason.
When the term is going to be completed.
My Lord, already again, one more election for the post of the office bearers is scheduled to be held in the next
We'll
week,
take
my
up.
Lord.
At
That's
which
the
number,
reason.
at which number it is posted today?
Please, my Lord, 97, my Lord. And my Lord, one more request. Even if it is listed on some other day, if it is not convenient today for this court to hear it, then, my Lord, I request that it may be listed for hearing on IAM, my Lord. It is listed for final hearing. That's the reason, due to paucity of time. Every time it is listed, no doubt, but it doesn't reach.
If it doesn't reach today, we'll see, we'll list it.
My Lord, at least 4 o'clock, my lord, please.
4
Please.
o'clock. Today 4 o'clock.
Please, my lord. 2:30 or 4 o'clock, whichever time, my lord,
Today doesn't read, then we'll fix the matter for hearing.
for hearing on IA, my lord.
Any other day you want?
No, my lord, if it is today itself, it's okay. Very short question is involved.
So
Okay,
that is what we
Akasmat,
are saying. If doesn't reach today, we will see what to do.
please,
If it doesn't reach today, then we'll see what to do.
please.
Serial number 64, my lord. Serial number 64. I'm the
Six-
complainant, my lord. Am I permitted to withdraw this complaint, my lord? Contempt
Six-
petition.
64,
64, my
learned
lord.
advocate. Granted, dismissed as withdrawn.
Please, oblige.
Lords, may I mention one? Serial number 40, my lords.
Serial number
Serial number 40 in today's list.
40,
40, 40.
40.
So we taken up some other day, my lords. Senior Assam incoming.
Fine.
Please.
And it can go after summer holiday.
Please, no.
10 to 17,
To mention, serial number 32, my lord, appeal for the
Number?
appellant, 32.
32.
But requesting for a short accommodation, no matter. I've informed the respondent.
What is it about? Read appeal. If no urgency, let it go after 19th of June.
That's all.
May I mention, my lord? Contempt petition, it is listed tomorrow. It's a very short question, my lord, it's a contempt. So I'm requesting your honor to place it little on the top of the list, if it is permissible. It is for tomorrow, my lords.
It's going to be taken up tomorrow.
Tomorrow, it is listed tomorrow. Just
Just
requesting,
tomorrow. And you want it to be top of the list.
the matter is very simple, my lords. I'll not take more than 5 minutes to submit before this court,
So you want it top of the list.
if it's permissible, my lords.
It is permissible, but then you have to go before the computer, not before the judge. You mention before the computer.
No, I in fact saw it. So the thing is that I was asked to move a memo before this court. Move a memo before this court. Lest this court
Move
goes.
memo. But you want top of the list, then you have to request to the computer, not to the court. That's, yes.
Serial number 102, time for the complaint,
10,
closed.
10.
102.
So what do you want?
I'm for the complaint paper closed.
Learned advocate Mr. R. Srinivas Gowda stated that the order under contempt brought under this petition is complied with. In that view, the proceedings does not survive. Full stop. Learned
Serial number,
advocate Miss,
serial number 77.
you are there in the second.
No minutes.
Also, in the aforesaid view, the contempt petition is disposed of, does not survive.
Serial number 23, my lords.
20.
3.
What do you?
My lords, it's already connected with contempt petition, my lords, but oversight it has been listed to them.
The delay is there, 225 days. Notice written.
No, my lord, it's connected already, my lord. 7/3/25, it's connected already. Connected with contempt petition, my lords, this matter. But oversight it has listed to
Then
them.
notice will have to go. There
Please.
is a delay. Notice returnable on
Date is given, my lords, 27/3.
20,
27/3.
27/3.
Okay.
In contempt, it is given.
Please, my lord. No, my lords, it's already connected with contempt petition, my lords.
Notice returnable on in delay application. 20th June.
Serial number 77, my lords. I have received the NOC for
Pardon?
I have received the NOC for appellant, my lords. I'll be filing the wakalat today, my lords. Can it be taken after 2 weeks, my lords?
No, my lords.
So
I
petition-
I object for the adjournment. I appear for respondent number 5. My lords,
But she is for,
My lords, I have received the NOC, my lords. I'll be filing it in the
one of
counter.
what will be
For
applying for.
appellant, my lords.
Then what is
but there is 37 years delay, my lords. Last time also they have taken time. They are just prolonging. My
she is for appellant. What can the hurry on your part?
lords, it may be listed next week. Any specific date may be fixed, my lords. It is only my request.
Learned advocate Ms. So and so
Though
that
though the order is not in their favor, they are putting up
appears
constructions,
to
everyone,
submit
everything.
that she has received the no objection
Please, my lords.
and
NOC
that
I
she will
have-
be filing her wakalatnama
Please, my lords.
on behalf of the appellant.
Please.
So paragraph, the wakalatnama may be filed within 1 week. The appeal shall be listed on 29th of April.
Please. Wait.
Yes.
I submit the serial number 102, actually it's 75 minutes. Sorry. I have submitted that the contempt is to be closed. That is serial number 75 in fact, not 102 minutes. Sorry.
Not, not
Not 102, it is 75 only.
not 102, but 75.
How much?
Same order, but not in 102. So 102 will continue to be.
Same order. So any other mention through VC, sir? Still number 1?
My lords, I appear for the
Full-
accused in this matter, my lords.
That's appearing
My
for the
lords.
petitioner in this matter.
My lords, on the last date of hearing, my lords had
What about this? This is late. Acha, that is all. That is all. Then other matter is not listed. Laxism. So what happened to appeal?
My lords, we have complied with the writ appeal, my lords, and on 4th March, I have even moved the memo to list it along with the contempt petition, my lords. However, it is not listed today, my lords.
Appeal
Lords, Writ
file
appeal 106, my lords.
106.
6
writ
of
appeal
25.
number 106 of 2025
Yes, my lords.
shall be listed and shall be listed on 4th of April. Before that date, the appellant shall remove all the oppositions.
Yes, my lords.
Failing with, the appeal shall stand dismissed automatically without reference to or order of court.
It has been complied, my lords. Grateful,
Contempt petition shall be listed along with the appeal.
grateful, my lords.
This is still number 2. Rohan V. Tigdi.
This is yesterday's matter. Yesterday's contempt matter.
The CEO is present, Lord.
My lord,
It's on.
with your lordships kindly, my lord.
Mr. Advocate General, there is an order passed.
I understand, my lord. I confess, my apologies, my lord. Your lordship may kindly fix it, if I may suggest, my lord. Let them meet tomorrow or day after, my lord. We'll see that it is sorted out. Your lordship may have it next week, my lord. Lordship may fix the meeting tomorrow or day after, my lord, or even today is no possible. If they are agreeable, my lord, we'll sort out and come back next week, my lord. I'm sorry, my lord, for the delay, my lord. There is, in fact, my lord, they ought to have done it by now, my lord.
25th.
Please,
Wait,
my lord.
By
Twenty-
the way
Your
he's
lordship-
saying it, I'll take his word.
This 27th, let us,
27th,
27th.
but I hope.
Let them have it today itself, my lord, at 3 o'clock in the CEO's office, today at 3 o'clock, so that there's no confusion further for communication, my lord. I'm sorry about this, my lord.
Mr. Advocate General is very confident.
No, I don't doubt him at all, Lord.
Then please cooperate.
Yes,
with
yes, of course.
With his confidence.
Yes, Lord, with his
Cooperate with his confidence.
confidence, of
Yeah,
course.
we'll see that it is sorted out, my
And,
lord.
tomorrow at 3 o'clock, we'll meet him. Lord. Tomorrow at 3 o'clock.
So when do you want, Mr. Shetty?
Tomorrow at 3 o'clock.
Then tomorrow, 3 o'clock, then your lordship may call it on next Monday at 4 o'clock, 4th, my lord, on April 4th. Now, instead of next week after next.
Next. No, let it come up next week, Lord.
Next week?
I'm saying tomorrow meeting.
Because next Thursday, Friday, I may have some personal inconvenience. That's the reason, my lord.
Then 2nd of April.
Wait.
2nd of April, no problem, my lord. No
Second.
problem. Well, we'll try and sort it out by then, my lord.
Learned Advocate General appears to request the court to adjourn the matter, adjourn the contempt proceedings to 2nd April, stating further that in the meanwhile, comma,
CEO is present. CEO is present as directed. CEO is present before this.
necessary. We have not direct. Whatever we speak, don't obey. Whatever we write, you must attend and obey.
Please.
That is the rule of court, first rule of the court. Judge may say anything,
Please.
irrelevant, relevant, out of anger, out of sarcasm,
Please.
out of humor. Don't look into it. You look the order in.
Please.
So we have not asked anybody to amend. Yes. Stating that further progress will be
Well, definitely, my lord. We'll see that.
arriving at the compliance.
Yes.
It's
Very
good,
good.
my lord. At least the CEO is present to see what is
Yes.
happening. my lord.
Yes. Next.
Grateful to my lord.
Seal number 3, Amit Nayak.
I appear for the petitioner in this matter.
Yes.
Subject matter of this contempt is the illegal sale of liquor, my lords.
This was kept for order. You are Amit Nayak.
Please.
Contempt petition is dismissed.
So PL matter, cell number 4, Mr. R. Srinivas Gowda.
Blood, I am for the petitioner, blood. Blood, blood, the petitioners are the residents of Attur village, bloods. Petitioners are the residents of Attur village, blood. Land bearing survey number 5 of Attur village, blood, is the Gundutop, blood. It is a forest like land, bloods. Bloods, in the year 1968, blood, that land is listed as Waqf property, bloods, under section 5(2) of the Act, blood. To constitute a particular property as Waqf property, blood, as per section 3(L) of the 1954 Act, blood, Waqf Act, blood, somebody is to be donated, bloods, or gifted that property, bloods. But there is, still, blood, the revenue records and the survey records speaks of that, blood, is the government land, bloods. Till 1992-93. Only, blood, by virtue of that notification, mutation is changed. But revenue records and survey records fix that, blood, it is the government land.
So here, what public interest you are? It is public interest.
Blood, they are all the
Public
residents of
interest
village,
is
blood. There is no other land available for the residents of that village, bloods. This is a government land, blood, that is to be reserved for the public purpose, bloods. But bloods, in the list, bloods,
It was reserved for public purpose.
it is to be reserved for the public purpose. Blood. But bloods, there is no pre-existing title to the Waqf institution, blood, to include that property in the list of Waqfs, blood.
Who says that it is to be reserved for public purpose?
Bloods,
You are saying.
it is the request of the villagers, bloods.
So nobody else is saying. Is it reserved for public purpose?
It is not reserved.
Not reserved.
Not reserved. Bloods. It is, bloods, it is included in list of Waqf properties, bloods.
That is, we have seen that.
Yes, bloods.
So what is the prayer?
Writ of and other appropriate writ direction, declare the gazette notification date.
How it got included in the Waqf property list?
Not your lordship may kindly see. 1954 Act.
No, that act we know. How it got included? Somebody donated it or what?
That's why no records to speak, bloods.
No records to speak.
No records, bloods.
For creation of Waqf and consequential registration of a property to be a Waqf property, there are some prerequisites.
Yes,
There must be a eradication of the.
yes.
Where is that here?
Well, it's coming up.
Somebody says and some authority inquires and records as public, as a Waqf property, it may not satisfy the requirement of it. Notice returnable on. Which date? 22nd April.
Obliged.
The case of the public interest petitioner is inter-alia that the property in question is erroneously recorded as Waqf property. Full stop. In this view, while responding to the case of the petitioner, the authorities shall come out with a stand to explain to the court as to whether the essentials in law for creating workup and treating a particular property to be the workup property are satisfied, comma, and if these ingredients are satisfied, comma, in what way? Next.
This is number 5, Sapiel, G. Balaji Naidu.
Yes, my lord. My lords, can I pursue your lordship to page number 12? That is the prayer, my lord. The relief which I sought in this petition. It's the first prayer, my lord. May I, my lord? The writ of mandamus or any other writ or direction directing the respondent number 1 to 5 not to issue Hakkupatra to respondent number 6 and 7 under Ashaya scheme formed in survey number 1 of Humpalgata village, Kasba Hubli, Taluk. Second prayer, my lord. To issue a writ of mandamus or any other writ or direction to the respondent authority to take necessary action against respondent number 6 and 7 for lodging criminal complaint, for making false representation and affidavit filed for availing allotment of site made to the respondent under Ashaya scheme formed in survey number of Humpalgata village, Kasba Hubli, Bangalore, Anekal Taluk. Prayer 3, my lord, to issue writ of mandamus or any other direction to the respondent number 1 to 5.
So by virtue of your very prayer, so it is indicated that it is not a public interest. The director in the private respondents, 6 and 7.
My lords.
So make a complaint to the authority.
D, my lord. I have filed a complaint, my lord.
Then
My
they'll
complaint has not been considered.
Then they'll take
In
it.
meanwhile, my lord, they are contemplating to issue the allotment of Hakkupatra in favor of 6-7. There is an complaint which before the Lokayukta, and the Lokayukta report also, that report also has been filed, my lord, before this court, my lord. That report is page 112, my lord. Annexure J, my lord. Annexure J, my lord. Can I pursue it, my lord? Page 112, my lord. Relevant, my lord, 111. Whereas an extent of 1 acre 22 guntas of land in Sampal culture coming within the limits of Samandar village, Panchayat, Kasaba, Anekal, as per the orders of the Commissioner Wide Order 7 so, an extent of 20 guntas was allotted to Ashaya.
Or learned advocate Mr. So and so for the
6 and 7 was there's a name also reference.
Additional government advocate for the respondent state and its authorities upon service of copy of the petition in advance. The first prayer in this petition, styled as public interest petition, is to direct respondent number 1 to 5 authorities to not to issue Hakkupatra to private respondent 6 and 7 under the Asraya scheme formed in survey number 1 of Humpalgata village, Asba Hubli, Taluka. The next prayer is to direct the authorities to take action against the said private respondents by lodging criminal complaint for making false representation. In this false representation for getting the for availing the allotment of the site under the scheme. Full stop. The further prayer is to issue the Hakkupatra only to the deserving aspirants of the scheme. Full stop. The last prayer is made to require the authorities to consider the complaints dated 17/125 and 18/125 made by the petitioners in respect of the alleged illegal, in respect of the allotment of site, described by the petitioners to be illegal, to the said private respondents. Full stop. Stated in nutshell, the grievance of the petitioners surround that instead of giving Hakkupatras to the deserving and genuine aspirants and the eligibles of the scheme to get the allotment, respondent number 6 and 7 who are given the Hakkupatras.
Who are already,
Who are?
They are already been allotted sites.
Who are already given Hakkupatra and allotted sites. Who are
They are
not
constructed
eligible, who are
houses, my
not
lord.
genuine, and that their Hakkupatras are required to be cancelled. Hakkupatras are required to be.
And Lokayukta proceedings also pending, my lord. My lordship may submit that also, my lord.
And the Hakkupatras are not required to be Kuputras are not required to be issued. It was also submitted that the matter was considered with Lokayukta also, and the report is submitted, paragraph. By very nature of the prayer and the kind of it, comma, it is clear, it is evident that the prayers are addressed to prayers addressed against the prior respondents, alleging that they have got the allotment of this site in the scheme without eligibility, and that the Kuputras to them are not required to be issued. Full stop. The court is afraid whether such a grievance, which is essentially and for all purposes addressed to the private parties, could be entertained in public interest jurisdiction. Full stop. Learned advocate for the petitioner invited attention of the court that the complaints by the petitioner are already pending before the authorities. Full stop. Correct. These are the individual cases which are to be looked into by the authorities. Full stop. The present petition is not liable to be entertained. However, without going into the merits, it is observed that if any complaints are received in respect of any illegible allotment or irregularity in the allotment in this Asraya scheme, comma, the competent authority shall be duty bound to look into it, and if found substance, comma, take necessary steps.
May want
Observation. No further observation, much less relief can be granted in this petition. It is the
my lords, may I make one sub?
I don't know anybody except myself. Yes, what is what?
My lord, in
A very great way of starting your matter.
my lord, rule, I am seeking a direction to implement the rules of this sample court which have not been implemented. If those rules are implemented, the judicial work will be reduced, my lord, and so that the courts can give a concentration on the ready matters and the hearing matters. Rule 12 says, my lord, of High Court rules of Chapter 13, which have also extracted in the petition. May I draw your kind attention to Rule 12, my lord, which I have extracted in the body of the petition. Page number 5.
Number 5.
5.
Yes.
My lord, there are about 77 type of cases are being listed before this Honorable Court, High Court, starting from arbitration up to habeas corpus. In all cases, my lord, whenever a case notice has been ordered, the procedure is, my lord, after issuance of notice, what is to be done, my lord? Kindly see the Rule 12, my lord. When a notice issued to a party through court is returned unserved, an intimation of that fact shall be given on the notice board of the court. Such intimation shall be put up on the notice board on the first working day of every week and shall contain the following particulars. Particulars means a case number and unless a different period is fixed by the registrar, which shall be noted in the said intimation, the party or his advocate at whose instance the original notice was issued shall accept when the notice has not been served because the respondent is dead, deposit into the court further process fee for the service of fresh notice and shall give particulars necessary for servicing it within 10 days from the date on which the intimation is put up on the notice board. If fresh notice is also returned, the same procedure shall be repeated. If notice is returned, unserved for whatever reason, the same shall be listed before the registrar judicial for the complaints. This rule has been violated. This sample court for office of the sample court for all these years, my lord. At no case in pending cases are not listed before the registrar judicial, except the fresh cases. We are not concerned with the fresh case. Whenever a pending cases notice has returned in respect of respondent, they straight away post before the court. In that way, about 40 to 50% of work, the court work is taken for these cases, my lord. It can be as well posted before registrar so that we will be knowing, we will attend it, my lord. If you don't attend, then it can be posted before the court. In all pending cases, old matters, my lord, whenever clerk notice that some defect of not taking steps or thing, then straight away it will be posted before the court. And then normally, with my experience, I'm submitting that court feels that if it is a old matter, why you are not taking steps, because we have not been notified by the office. Let them notify, make a procedure. If let them list it before the registrar. Even in Honorable Supreme Court, my lord, that is then we will comply with them. This procedure has not been followed. Therefore, I request your allotment kindly direct the respondents to take note of this.
Third party in person. That's the petitioner hearing. In this petition, styled as public interest petition, claims to be the practicing lawyer since 1977 to submit to the court that he has the practice of 48 years and that therefore out of experience and that therefore in such capacity the present petition is filed. The prayer in the petition filed invoking the jurisdiction of the court under Article 226 of the Constitution reads as under. So court prayer, bracketed portion, paragraph 9. Also pass such other orders, 1 and 2, Roman 1 and 2, or A and B, whatever. Rule 12 of Rule 12 and 12A
of Chapter 13. Of Chapter 13 of High Court Rules.
Of the High Court of Karnataka Rules 1959, which is quoted in the petition, reads as under. Quote kar do pura rule. Page 6, 5 and 6.
Even 13 also relevant, my lord, where it says, if a notice issued to party through court is not served in the ordinary way on 3 occasions, the matter shall be posted before the registrar for further orders. It has to be posted. No posting in all pending cases.
The plank of the grievance of the petitioner is that the working of the said rule leads to waste of the time of the court. It was sought to be submitted that miscellaneous matters should not be placed before the court straight away, so as to And that it should go to where? Register,
Before registrar, it should.
to the register judicial. Full stop. The court is of the imminent view that subject matter of such kind, that for such grievance, for the grievance of such kind and nature, writ of mandamus is neither contemplated nor entertainable, nor the plea,
I've given a representation,
nor the plea in that regard is entertainable. Full
I've
stop.
given a representation to the authorities.
The court is of the clear view that such matters are to be addressed on the administrative side only. Full stop. The petition is thoroughly misconceived and is dismissed with cost
My
of
lord,
rupees, cost of rupees 5,000
My lord,
as a token cost
my lord, I've given a representation
to be paid to the Gujarat High Court legal, to the Karnataka High
that
Court legal.
I can
service.
pay. My lord,
10 days.
I've given a representation on administrative side. No action was taken after 6 months. Therefore, I come here, my lord. I've given representation. No action was taken on my representation.
Cost of 10,000. For arguing after passing of completion of the order.
My lord, I request only, my lord, reduce the cost. I've brought only one issue so that it saves the judicial time. Kindly reduce the cost.
This stage, learned advocate for the petitioner request that the court proposed part may be deleted. Full stop. Taking a lenient view, looking to the aspect that the petitioner is a practicing advocate, the cost part is deleted. Next.
Number 7, Mr. G.R. Mohan.
Don't write 10,000, only 5,000, then the two. Two in this part. In the facts and circumstances case, the present writ appeal number 38401 of 14 and allied petitions are released.
Yes.
They shall be placed for approved orders on administrative side.
Please.
It was heard for earlier bench quite extensively.
Yes,
So we are thinking.
Yes, please.
Seal number 8.
As for the petitioners, my lords, in seal number 8 to
Bench
13.
matter.
In all these matters, my lords, I have filed application seeking to amend the prayer.
Writ petition 57990 of 17 and late petition. Yes.
Seal number 8 to 13, my lords.
Yes.
I filed application seeking to amend the prayer, my lords. The applications are on
Filed very data.
I number 2 of 2025, my lords.
What prayer you made?
Consequential prayer-
What prayer you had?
A consequential prayer, my lord, seeking to direct the respondent authorities to issue transport permits. I number 2 of 2025, my lords.
2 of 20.
Please. Page number 2, my lords, would find the prayer that I seek to incorporate. In terms of the orders passed. by
A
the-
number 2 of 25. Having heard learned counsels for the respective parties, the amendment in the prayer clause deserves to be granted. Paragraph accordingly, following prayer is permitted to be added in the prayer clause in the main petition. So it is to be quoted as one as small into bracket Roman 1 small a. So this is the so all four matters same order separate.
Can I request for the interim order as found in page number 212, my lords?
Is there
Please, my lords. Annexure J, my lords, would find it at page number 212.
the amendment shall be carried out forthwith. So submitted by learned advocate for the petitioner, Mr. So and so and so, Mr. Anirudh Anand.
Please.
That in the similar writ petition number
12508 of 2024.
12508 of 2024, this court has issued notice and has also granted interim relief.
Please, my lords.
Full stop. In that view, since the petition is similar in facts and identical in the issue involved, there shall be notice in this petition returnable on
Because the main matter is still pending before the Honorable Supreme Court. So
But then this connected is kept when?
there's no date, my lords, because my lords have directed to be listed after the Supreme Court hearing. In
Relief, relief is granted.
Please, my lords.
What is? Full stop. Issue identical issue involved. Full stop. This is the connected one. Full stop. In the connected writ petition number 3111 of 24.
Please.
Comma. The court had an occasion to pass the following order on 25/3/24. So, quote the order. As the interim relief is granted in the aforesaid similar matter, comma, by interim order, comma, in the present case also, comma, it is directed that the petitioner shall be permitted to carry on foreign operations and the authority concerned shall issue permit on payment of royalty as per the existing notification, provided that the petitioner possesses foreign plan and the environment clearing certificate.
All minutes. Seal number 8 to seal number 13.
Same order.
Grateful.
Number 14, Mr. Kulkarni Muralidhar. Number 14, Mr. Kulkarni Muralidhar Lakshman Rao.
Yes, what is it?
May please. In this petition, Your Honor, a demand notice issued by respondent number 2 is challenged, which is under Karnataka Mines and Mineral Concession Rules. Your Honor. The petitioner is a.
You were heard explanation letter dated 10/9/24. You were heard or not?
Yes.
You were heard or not?
No, Your Honor. This is first appearance.
No. You were heard before passing of the penalty order.
No, Your Honor.
It is the explanation letter dated 10/9/20.
No, Your Honor. I may be permitted to read the notice. I have produced a copy of. It is said, Your Honor, I am a valid license leaseholder and I have granted permission from the government. And on 5/7/2014, Annexure C, Your Honor. Page number 51 may kindly be looked into, Your Honor.
This order is appealable. You copy. You were heard before passing.
No, Your Honor. No, Your Honor. Since they have raised the issue that it pertains to Green Bench.
Mr.
My
Thompson,
submission was that, Your Honor.
it is stated that you were here were called upon, not
I have heard by court officer, Your Honor, in respect, I have
This
my
explanation, kindly go to page 60. Go to page 60. Page 60.
Please. But it is wrong, Your Honor. Because there is no reference that I was heard in the notice.
Kindly go to
Yes, sir.
reference number 3.
Yes, sir.
Your explanation letter dated 10/9/24. It was by your explanation letter.
Yes, Your Honor.
Then?
My submission, Your Honor, in this demand notice, he has imposed a fine by exercising power of a special court, Your Honor. And this is a penal provision wherein a criminal case, under section 30B of the MMDR Act, special courts are established, Your Honor. So instead of filing a private complaint, he imposed in the notice itself, he has imposed fine, Your Honor. It is styled as a notice, Your Honor. The title may kindly be looked into, Your Honor. On 12/12 to the annexure E, Your Honor, it refers as a notice. But in the last page, Your Honor, the respondent number 2 has pleased to pass order that therefore you are, I read just 2 pages, last 2 pages, sir. Therefore, you are hereby called upon as to why the fine of 5 times royalty of 64,056 for the violation of Karnataka Mines Mineral Constitution Rules 1994 as per Rule 44 and rupees 25,000 as per Rule 63 be imposed by taking legal action as per notice at reference number 2. You were directed to offer the proper explanation to the office within 30 days of receipt of the notice, failing which appropriate action will be taken according to the rules by considering that there is no explanation on your side. The explanation offered by at reference number 2 are not proper. Therefore, for violation of Rule 42(1) of Karnataka Mines Mineral Constitution Rules, for encroaching and mining, transporting outside the sand mining license area is punishable under section Rule 44(4). Hence, fine of 5 times the royalty of rupees 64,56,000 is imposed, and fine of rupees 25,000 is for violation of Rule 63 is imposed. So he has no authority, Your Honor. Section 22 of the Karnataka Mines and Mineral Act clearly says, my lord, no court shall take cognizance of any offence punishable under this act or any rules made thereunder except upon complaint in writing made by a person authorized in this behalf by the central government or the state government, Your Honor. So let proper course be taken, Your Honor. And even 6.3, there is a reference that clear 30 days to remedy the defects, Your Honor. 30 days time is also given. So also in 44 also.
Which section you are relying on?
First, I have referred section 22 of MMDR Act.
Act.
Yes, sir. In my petition, I have referred the same.
In page 39.
Section 21 of the Act refers about the punishments, Your Honor. And so also Rule 44 of the Karnataka Mines and Mineral Constitution Rules refers about the penalties, Your Honor.
Counsel, government advocate. Under Karnataka Mine and Mineral Concession Rules for offences under Rule 44, proceedings have to be initiated before the JMFC court, right? It is the competent court.
My submission, Your Honor. This honorable,
No, which is the competent court? It's JMFC court, right?
no, Your Honor.
Then which court?
As per, I have the notification, Your Honor, in exercise of the powers conferred by the subsection 1 and subsection 2 of 30B of Mines and Mineral Development and Regulation Act 1957, the government of Karnataka with concurrence of High Court of Karnataka hereby constitutes special courts for the purpose of said section comprising of the courts of principal district and session judges of all districts in respect of their respective areas.
So,
This notification-
it's the Sessions court. You need to verify that.
Yes, Your Honor.
Papers, my lord, my lord. Can you have this next week an assessment?
No, in this case, the senior geologist himself has imposed the fine. That's the reason.
Submission that
Yeah,
is in-
it can't be.
Give copy
Two
to.
copies.
Please, in fact, I have submitted the copies there, Your Honor, and there is,
You
I
are-
have came from Harvard bench,
Harvard went, so that's the reason.
What's your name?
Kulkarni Muralidharan.
But then. Please
That's
see
why I'm
notice.
handicapped. my lord.
Will receive notice.
Very well.
Notice returnable. Heard learned Mr. Kulkarni. Notice returnable on. When shall we keep, Mr.? Next date,
Any date,
7th April,
please.
7th.
Applied.
Writ appeal matter, still number 15, Mohammed Taib.
Respondent.
Kindly see para 6 at page 15 of the learned single judge's order. my lord. The factual aspect is the petitioner first respondent claims that a particular land is Kabristan notified under the Waqf Act, and an entry is made in the municipal records, but somehow it has been deleted is the complaint made. The Lordship may kindly see para 6, my lord. However, this court is of the considered view that given the nature of dispute, especially with the petitioner undisputedly having the advantage of revenue entries until the year 95-96, and that the fourth respondent is shown as the owner of the subject property without a particular deed in its favor, the question of consideration in this petition must be limited whether the fourth respondent is justified in altering the revenue records for the subject property in its own favor. Fourth respondent does not even contend that any notice was issued to the petitioner for the change in the revenue entries, or that there were any proceedings before the revenue entries that stood in the name of the petitioner for decades. It is on this ground the learned single judge proceeds, Lord. On the basis of the document, Your Lordship may kindly, petitioner himself has produced the document. Page 93.
You are the city municipality.
I am the city municipality, my lord.
Yes.
He claims an entry in his favor during 82-83 in its favor. Kindly see, page 93 is the book pertaining to 1975-76 onwards.
Page.
Page 93, annexure yes. It's in Kannada, my lord. Typed copy, English copy is at page 95.
Yes.
The entry reads,
Yes.
Haribodi
Yes.
it should be assessment accepted. The next document is page 96, of which the translation is at page 99. For the first time, it is shown as
an assessment register for the year 82-83 in the owner's name, Hire Baudi land, Mohammedan burial ground, 10.14 acres. Name of the occupier exempted, which learned single judge proceeds on the basis that it is continued up to 95-96 and thereafter it has been deleted. Actually, petitioner himself has produced the document from the book from 95-96. Kindly see, that would be page 102. Translation is at page 103. Description of the property, Hire Baudi land. Name of the owner, CMC, is shown. Of course, my lord, I have the original book also. There is no entry in the book even for the year 82-83.
82-83 is produced.
82-83, which they have produced. The entire book, there are 3 books from 1975-76 to 81-82, 82-83 to 81-82 to 94-95, and 95-96 to 2000-2001. In any of the book, this entry at page 93, that name of so-and-so is entered as Kabristan, etc. No such entry is found in the book. Of course, my lord, they claim that there is a Waqf notification, therefore their name should be entered. If the court were to say, including that question with regard to 82-83 entry, which according to us is not in the original book, even according to them, 95-96 also it is not there. But now the learned single judge says, you have deleted it. It is not deletion. If the inquiry is to be made with regard to entering their name afresh, right from the year 82-83 or this thing, we have no objection that would be made. But learned single judge says, there is an entry from 82-83 to 95-96, and now how did you delete it? Actually, in the correct.
Originally, it was not there.
Original books, I have also
It was not
got them. It is not there.
It's not there.
Now, the learned single judge has come, this is mistyping.
Of course.
Prayer of the petitioner was to enter the name.
Enter the name.
That wrongly disabled learned single judge. Delete its own. Post of the heard learned advocate, Mr. Learned senior advocate, Mr.
CH-1 and 6.
Yes.
But also permit me, I'd like.
Yes.
Lord, even the
You
document.
are appearing for
Lord, the respondent number 6.
number?
6, my lord.
There is no 6.
In the writ appeal, your lordship. The next page on top.
Why? So originally it was 5 respondents. How come that you are there?
I was in the writ also, my lords.
All right. This one of the petitioner is arranged. Yes. Yes.
Lord, all I'm saying is the learned judge has taken the fact of annexure in annexure R, that the name of Hari Baudi is entered.
Name of?
Hari Baudi is entered. The name of Hari Baudi is what is notified also in the corrigentum. Now, as a Waqf property. Now, that has been deleted unilaterally. That's all the case.
Hari Baudi is not deleted. It continues even as on today. The entry after Hire Baudi, there is an entry saying Mohammedan Kabristan, etc., which is not officially made according to us.
Kindly see then page annexure T, page 96.
the typed copy is been put only Haribodi, but in the original, your lordship will see 93 for a moment. The second line is there, but not legible. 93 for a moment. '93, my lord Scott, that's the typed copy. Lord, I understand that it is in Kannada. I only want to show to my lords, after Haribodi, there is a line down there which is not legible. That becomes legible in page 96. Page 96, Lord, may I just impress upon it. Haribodi Sthana Kabrastan anta ide. It is Haribodi Kabrastan. And kindly see name of owner also is saying Kabristan. These are entries of 75, 76. No, it is their documents. They have nowhere said that these are documents created or anything of that sort.
You got Mr.
Therefore, it was always a Kabristan. It continues to be a Kabristan. By unilaterally, they have changed. The learned single judge has only said, you cannot change unilaterally. You conduct inquiry if you feel so. That's all, my lord. My lord, I would say, my lord, this is really not a, sorry.
No, page 96.
Please.
So any such original is available.
It's not that.
That's
This is the
that's the
first
point.
book of original from 75, 76 to 81, 82. Only entry is Haribodi Jaga. That is that Haribodi place. Haribodi Jaga. Next book. This is this end.
See, in these if the entries have to come, there has to be a proceedings.
Yes, my lord, because it was notified under section 4 of the Waqf Act.
No, proceedings, where is it recorded? In the revenue document. There should be proceedings recorded in the revenue document.
They only mutated and gave it to us. They let them produce the, say that.
You can just scrutinize it.
Let them produce it.
This is
No,
the
kindly
next book for the year.
See, anything without a proceeding will be considered erroneous.
Kabristan is not there anywhere in the book.
7-4.
Haribodi is the name that stands from 75, 76, right from town municipal.
No, just show it to us. Let us have a look at it.
In this, my lord, if you have to see all the records.
Keep your pen aside.
Only two documents, I mean, registers are there. We'll have to see all the registers. No, just by, and they have only issued this. They have not denied these documents. And it is not their case that we have fabricated something. There are two government. We are also a part of the government created by the government. They are also.
Correct. But see, when in these registers, whenever there is a name coming up.
Please. There is a survey number.
Unless it is from time immemorial.
Yes, Lord.
There has to be a proceeding for it.
There is a proceeding.
And proceeding is also recorded.
Proceeding is under section 4 of the Waqf Act.
Yeah, is it recorded somewhere?
It is there, my lord. All those records are there. We have produced the notification. We have produced the gazette notification.
That alone will not suffice. See, gazette notification, we have found that it to be erroneous on so many occasions.
But it is not found erroneous here with utmost respect, may I say. It is not found erroneous here. It is a gazette notification which is issued by the deputy commissioner or a survey commissioner appointed by the government under a central statute. They have conducted mahazars are there and document is there, survey report is there. Pursuant to this name has been changed as Kabristan. And there are graves over there, your lordship. May order for a survey to see whether there are graves or not in that survey number.
No, it's not there.
And kindly see,
entry, whether it is
kindly see page 79.
If it is to be considered afresh, no objection, proceedings will be done.
Kindly see 79.
But single judge records a finding that there is an entry. And how did you delete it?
Yes,
there is no entry in the book at any point of time. That Kabristan is not there.
Kindly see page 70 for a moment. page 70 is a letter issued by the DC. The English translation is filed next, page 70, my lords. Annexure H. Lord, there was a request for granting these lands for some official club somewhere. Because this land now has come within the town. That is where all the problem has started. On verifying the documents, may I read? Of the Tahsildar Chairman Waqf Chitradurga from 29/3/83, the application seeking grant of aforesaid land for official club is hereby rejected since the land belongs to the Waqf property. So it is not just one stray book that there has been any difference. Periodically, there have been communications from the authorities where they've accepted this to be a Waqf land. It is their own letter. They, only after seeing all this, the learned single judge, my lord, felt that there are records. Suddenly you have changed it to Nagara Sabhe. They have not changed it to Haribaudi. They have changed it to Nagara Sabhe in 95-96 unilaterally.
No, it is not changed. Haribaudi remains even as on today.
But the
even for
Kabristan is
23,
changed.
24.
The Haribaudi Kabristan is changed. The word Kabristan is deleted.
I don't know, holding in favor of the original petitioner, the Waqf institution, in respect of a mutation entry relating to which land?
Lord, the land Haribaudi Jaga in
Relating to the land which was
please, Lord, in the
identified in the revenue record as Haribaudi.
Haribaudi Kabristan.
Haribaudi Jaga.
That's the difference
No,
between us.
Kabristan is
Right,
not there.
Haribaudi land,
Haribaudi Kabristan.
comma. On a single judge directed by allowing the petition to restore the revenue entry for the subject property, for the property in question, for the said property in favor of the petitioner. The said property was entered in the name of the appellant city municipal council in the revenue record in respect of which, comma, making grievance, comma, the writ petition was filed by the Waqf institution. As learned single judge allowed the petition, comma, the city municipal council, the appellant hearing has called in question the said judgment and order of learned single judge dated 10th April 2024. In course of the submissions, while assailing the impugned order of learned single judge, it was highlighted by learned senior advocate Mr. So and so for the appellant that page 95 of relating to which year?
Page 95, I relied to show that Kabristan is shown as in
No,
99 and 95.
95 is belong to which year?
82, 83, my lord.
No, 95.
Page number 95, my lords, 1976, 77.
1976.
95 or
Demonstrated that in
96.
the year 1976, 97, 77.
Even in that also it says Kabristan down. It is not legible, that's all.
Come on. The description
It's
of
not there
property-
in the book. I don't know how it is being said.
Description of the property was shown to be as Haribaudi land, and the exemption was granted to the holder of the land from assessment of the land. it appears that during 1995-1996, it appears from the copy of the revenue record, into page 99. Bracket over that, the year 1990, in the year 1982-83, below the description of the said property, Hari Bavdi land, it was mentioned as, also as, it was additionally mentioned as, Mohammedan burial ground, and the exemption from assessment continued. Full stop. In the case of the petitioner Wakaf institution before learn a single paragraph was inter alia that the said entry as Mohammedan burial ground continued to exist in the revenue records up to 1995-1996. Therefore, learn a single judge, it was submitted, therefore, learn a single judge, 1995-96, full stop. Refuting the said position, it was further highlighted on behalf of the appellant, City Municipal Council, that in the year 2015-16, the description of the property never contained that it was a burial ground. However, what was described was that it was a same land belonging to the City Municipal Council, who was the owner.
Description of the property, Hari Bavdi.
In other words, it was submitted that it was only in respect of the year 82-83 that the description Hari Bavdi land had the addition about burial ground.
But until 95-96, sorry to, from 85 to 95-96.
Paragraph. It is the case of the original petitioner that the record indicated in the year 1995, revenue record indicated in the year 1995 that it was a burial land. Full stop. In course of the submissions, paragraph. It was the case highlighted by learned advocate Ms. So for that the land was Hari Bavdi land. Land was burial land in the year 1995. In course of the submissions, learned senior advocate for the appellant emphatically submitted and showed, submitted that the mentioning of description into burial land, Mohammedan burial land, appears to be entirely inaccurate, inasmuch as in the original register of properties, right from the
year 75-76 up to date.
1975-76 till date, there is no such description found in respect to the property in question, which is continuously shown as Hari Bavdi land. Full stop. It was therefore submitted that the order of learned single judge, that it was therefore submitted that learned single judge has committed an error in passing the order to allow the petition. Paragraph. A strong prima facie case is made out. The appeal is admitted. It may be listed for final hearing on 23rd June. The impugned judgment and order of learned single judge is hereby stayed.
Please.
So number 16, it's a state appeal.
Delay. Notice returnable on 23rd of June.
So number 17, to K. Abhinavanan.
Remember?
Please, let's do the order to annexure G1 at page 93 to 2000, 93 to 101, 93 to 100. The Kannada version is at page 93 and typed copy is also there, and the translated version is at page 98, my lord. Through this order, the third respondent herein is conferred occupancy rights to an extent of 2 acres 37 guntas in survey number 353 of Kodiyala Karyanelli village, Vidhi Obli Ramnath Talukku district. And in this petition, my lord, the appellant was not a party. And after getting this tenancy rights under the provisions of the Karnataka Land Reforms Act, the third respondent started interfering with the possession of the land measuring 2 acres 37 guntas, which was purchased by appellant's father through the sale deeds of 1963 and 64 at annexures C and D. At annexure C, my lords, your lordship may kindly look into only one sentence. The translated version of annexure C is at running page 69.
So this 353 has the total area of 6 acres and 30 guntas.
Yes, ma'am.
Survey number 630.
Total extent is 6 acres 13 guntas.
Out of which the petitioner.
Out of which the third respondent is conferred occupancy rights in extent of 2 acres 37 guntas.
So the dispute is which part constitutes 2 acres and 17.
Please, my lord. My lord, this.
First leading of evidence.
The
First leading of evidence. Which part is granted or which part of 2 acres and 70 guntas fall to the grant, or it is subject matter of sale deed, is a matter to be adjudicated. That can be done only by leading evidence. That is the view of the single judge. What is wrong in it?
Well, my lord, I am ready to go before the civil court to establish that this land is purchased by my father.
That is
But
what
the problem, my lord, the jurisdiction of the civil court is barred under section 133 of the Karnataka Land Reforms Act. And that point may kindly be clarified, whether this particular land conferred occupancy rights in favor of the third respondent, whether it is tenanted land or the land covered under the sale deed, its own. So if that clarification, one more submission, my lords. See, the 2 acres 37 guntas of land.
The sale deed do not reflect this.
That is where.
The sale deeds do not reflect this.
Sale deed do not reflect the survey.
Doesn't. There's the sale deeds they are relying on do not reflect the survey number. They are claiming an interest in this land by virtue of 2 sale deeds. If my lord would see at page 28 and 29. Page 28 and 29.
Whether petitioner purchase a portion of 353 under the sale deed involves complex issues and same as the That's the crux of it.
One sentence may kindly be perused in Annexure A, my lord, which is passed by the Karnataka Appellate Tribunal, in which the fourth respondent, Karyappa, has admitted
So the
for having
remedy-
sold 2 acres of land in survey number 353.
The
Favor of
remedy- the remedy is available anywhere except in the writ jurisdiction. We do not know where. But we know that not under the writ jurisdiction, dismissed.
This is as against the learned single bench's order, despite having an earlier order by this honorable court, wherein it was held that the respondents should not have been granted, the respondent should not have been granted 3 acres which they sought for, as opposed to 1 acre sought for this appellant herein. There's a positive order passed by this honorable court. If your lordship may kindly see, that is at page 154, your lordship. Your lordship, in 2015, this honorable court had held the relevant portion, your lordship, at paragraph 12, page 166. In the instant case, without following the procedure prescribed under law, that by private negotiation, 3 acres of land has been allotted to the fourth respondent, though he made an application for allotment of 1 acre of land. Hence, the said allotment of industrial plots cannot be sustainable. This court, while entertaining the writ petitions, granted an interim order on 19/1/2007, directing fourth respondent to maintain status quo insofar as industrial sites in question. Subsequently, on 8/2/2008, permitted fourth respondent to carry on civil construction work of its proposed project of servicing earth moving vehicles in area of 1 acre. Further, it was made clear respondent 4 shall not carry on any construction, nor shall put to use any of the remaining area. In view of the said interim order, the fourth respondent is not put up any construction, and entire 3 acres of land in plot 16 and 17 is lying vacant. Hence, it is appropriate to direct the second respondent to reconsider the matter afresh and consider the applications of the petitioners as well as the fourth respondent and take appropriate decision in accordance with the regulations. And your lordship, the allotment letter dated so-and-so, registered lease deed, all of that was set aside, your lordship. This was the order in our favor. They were asked to consider. What they do is, the 3 people or the applicants, they call them, again they go forth and again give the entire 3 acres in their favor. One is, your lordship, this is only for industrial purposes, for the manufacturing of any of the items. They've given entire 3 acres to these people to run a service center. It's not even a service center, it's more of a sales showroom. Your lordship, even the latest photos as of taken as of day before yesterday, there are only trucks parked in the entire area. Your lordship, they've gone way beyond what they were supposed to do. Even if they are to give them, they could give them 1 acre.
The lady sitting in the 3rd row, in the last row, should not use the form. It appears that she is using for different purpose. Even if she is using for some good purpose, tell him not to see the form while court proceedings are going on.
May I, your lordship? Please. Your lordship, subsequent to this, they have proceeded to again give them the entire 3 acres. And the reasoning in the impugned order, your lordship, is that the father of the appellant earlier was given some land which was sold off.
and that these entire 3 acres they are utilizing, there is no difficulty, and therefore they have proceeded to give it to them. This is in complete contradiction to the earlier writ petition order, Your Lordship. Page 153 is the demarcation sketch also.
The earlier petition order,
Your Lordship, that is at page 154, Your Lordship.
150, you read it.
Please.
So your application was considered and thereafter this order.
And thereafter, Your Lordship, they proceeded to again give them the entire 3 acres. Therefore, we again came by way of a writ petition. That is the impugned order at page 34, Your Lordship.
One 18665 order, where is it? Page number?
Please, Your Lordship.
18665.
Page 160,
No, 154, same, 1866.
154 onwards, Your Lordship, please. The relevant portions at para 12, Your Lordship. And the present writ petition, Your Lordship, the impugned order, Your Lordship, they proceed to say that he's anyway utilizing the entire portion and unnecessarily raised an issue with respect to the appellant's father who was earlier allotted a land which the son's nowhere concerned with. Son's an engineer who is going into manufacturing of components, Your Lordship. So they are trying to say that the father which was granted earlier for the manufacturing of rubber had ended up selling it. Your Lordship, his entire rubber plant, due to that policy, government policy, had gone into losses. The bank had even attached the property at that point of time and there was no other option. And the second time when the father purchased, it was through another person, not KIDB. This is all raised by the beneficiary, Your Lordship, who's now been given 3 acres. KIDB did not go into that, but now both are trying to sail together, raising other issues of the father, which has nothing to do.
Come to page number 166.
Please, Your
Para number 12.
Please.
See, they had made a request of 1 acre,
Please.
against which 3 acres were allotted.
Please.
This was found fault with by the court.
Please.
And because of interim orders, no constructions were put up.
Yes.
In the best interest, it was ordered that all the applications be considered afresh,
Fresh. Please.
including all the applications, not just limited to the petitioner and the contesting
Correct,
correspondent.
correct, correct.
So that means to say
Please granted.
Initially for 1 acre, again for 2 acres. Your lords may kindly see para 13 of the order. It's clearly spelled, page 48, my lords. It may also be necessary to take note at this juncture, though the memo filed with the respondent KDB refers to application filed by respondent to Vijay Sri, so and so.
Who is for the authority?
Please.
You are for the authority.
Please.
In the original petition, reply was filed?
It is only 3 acres only, page number.
No. Reply was filed in the original petition. Where is that? Produce.
Please.
My lord, huge industry has come up, my lords, now.
There is no huge industry at all. It's all vacant still. Show me the photographs.
We understand prima facie she has to establish right, but then produce
Please.
reply.
Please.
20, when shall we, week time?
We will also.
10 days, 3rd of April.
Please.
Still number 19. The Rashekar is
Delay
I beg to appear for
28 days.
Delay is there.
Notice or anybody is appearing.
But private respondents are not yet represented.
So notice returnable on 29th of April.
Please.
still number 20.
Lord, I appear
Data
for the
PV.
respondent.
Grateful.
Lord, it's the
Lord, may I?
appeal. We had challenged the interim order dated 19th of December 2024.
Lord, may I, my lord, make one submission, my lord, before my learned friend says anything, my lord? Because
Let me complete
subsequently,
my,
my lord, interim order has been
submission.
passed where
The matter is next listed on 2nd of April at 2:30, my lords. I shall seek instructions whether we are going to continue with the challenge as such.
yes,
Which matter is listed?
My lords, we have only challenged the interim order dated
No, no.
19th of December 2024. my
No,
lords.
no, on 2nd April, which matter is listed?
my lord, the main matters,
Main matter.
main matters are
Order
listed.
is still pending adjudication before the
No,
signature.
today it is for what?
They have challenged the interim order granted.
As a main matter is,
It's
Yes,
still
sir.
pending. That's why I'll seek instructions whether it has become infectious and
that is.
make submissions on the next date.
So when shall we?
My lords, on 4th of April, because
4th of
2nd
April.
it's listed before the.
Stand
signature.
out to 4th of April.
Please.
2:30 will,
Very much, my lord.
to be listed at 2:30. In view that the learned additional government advocate will be taking instructions.
Very much.
Previous matter, comment advocate may be directed to take notice of respondent 1 to 5.
All are private parties there.
No, 1 to 5 are my lords respondent, government advocate, my lord. 6 to.
1 to
In
5.
the earlier matter, I'll take notice for 1
Notice.
to 5.
19. Learned additional government advocate. There Mr. Rajsek,
Naveen Chandrasekhar.
Naveen Shekhar,
Chandrasekhar.
Chandrasekhar, Naveen Chandrasekhar. Accepts notice on behalf of respond 1 to 5.
So 1 to 8, my lords. 9 and 10, my lords, I'll pay.
1 to 8 you will,
Yes.
1 to 8.
Yes.
The rest of the respondents will be served.
Great.
Still number 21. Mr. Million.
Appearing for the cavator respondent, my lords. I pray for 10 days time, my lords, in this matter.
Which one?
Serial number 21, my lords.
21.
Short
Why?
question in this matter, my lord.
My senior is held up in court hall 21.
Produce the judgments, madam, producing the judgments.
On the last occasion, my lords,
Copies out to the other side.
That. Palani well. Then is produced.
The list regarding earnest money has been decided by the Supreme Court. My lord, in the serial number 4, my lord, the Satish Batra's case, the final last judgment decided in 2012, my lord. Previously, all judgments has been referred in this matter, so I just produce it for the reference purposes. Law is laid down way back in 1926 in Kanwar Chitrajit Singh versus Har Swarup Singh, my lord, where it was held, earnest money is part of the purchase price when the transaction goes forward. It is forfeited when the transaction falls through by reason of the fault of the failure of the vendee. This has been continually held in all the cases. In number of cases, the last case decided by the Supreme Court is this Batra's case.
So I would like to make some more research on the point, my lords. Lords, kindly grant me a week's time. May be heard, my lords.
This judgment, Palani will not apply.
Please, my lords, I had passed it over.
2025 1 SCC 559.
That one was.
Please, my lord, it is referred to in the impugned judgment. I had passed.
And the judgment of this court in, where is that?
My lord, that judgment pertains to my lord.
That writ appeal number 1217 of 24. Just go through two judgments, whether they are applicable or not.
Yes,
Please,
my
my lord. Please.
So I'll also go through. We'll keep it on 22nd.
22nd. Much obliged.
Twenty-two, 23 are adjourned. Number 24, Mr. Raghavendra G. Gayatri.
Here for the petition. Appellant.
I appear for the respondent. I appear for the respondent, my lord.
My lords, matter relates to my lord's selection to the post of sweeper. Lords, what had happened, my lords, is my lords, one post for SC category and one post for general category was called. And my lords, in the while selecting the candidates, person who was more merited and also was an SC candidate was placed in SC category. And my lords, the respondent number 3 herein filed a writ petition, my lords, in the year on 7/3/2024, after delay of 1 year of my appointment being issued, stating that, my lords, as per Saurav Yadav case of Supreme Court, that person who is more merited, DHOS is in which category he has applied, should get general merit category. Because that is what is held. But my lords, my prayer, my lords, that I was working, it is a group D employment. My earlier work, I have left it. And for 2 years, I have been working. I had pleaded with my lords citations before the learned single judge. My lords, at page 35, 17, paragraph 3, with respect to merits of the matter, my lords, I have no qualms about. But my lords, what I am seeking before my lords is, my lords, there are vacancies. I have left my previous job and it's a group D employment. That my employment may be saved. To that extent, I have come before my lords.
Then you are protected till the list is.
They are proceeding with the list, my lords. They have already prepared the list, not published yet, but I will be ousted off if that is made, my lords.
Then this may not be subject matter of this. It might be a different cause of action.
My lords, para 17.
No, you just explained.
17, I agree, my lord, but 17.3 may be once looked into, page 35.
So if you are not finding place in this fresh select list,
I will not be finding place for this.
Will it not be a fresh cause of action?
Very same select list, I will be ousted of, my lords. Very same select list, I will be
ousted from service.
Yes, my lords. For the reason that I am not merited. My lords, may kindly take page 86.
Now in the select list, originally you are selected.
Originally, I am selected. But
You are selected.
I will go out.
By wrong interpretation of law.
Indeed.
Wrong interpretation of law. Now, you are harping on the ground of delay and laches.
No, I'm not harping on his appointment at all. There is no delay and latches also.
There is no delay and laches.
I'm only praying, my lords, my appointment may be saved. That's it. I'm relying on 2010 Supreme Court judgment of Honorable Apex Court. Para 31. It was not 142 exercise, but
So,
para.
when a single judge's select list is upheld.
No, select list is asked to revise, my lords. He has directed to revise the select list.
Is quashed.
Yes, my lords.
So
Lords,
you're-
may I read
So
17?
you are the petitioner? No.
No, I was the respondent.
I was the petitioner, but I challenged the select list on the ground that the person who has claimed reservation, his case is required to be considered even for general merit. Person who has secured more marks, his case is considered against reservation. Therefore, my lord, it is the state has conceded before the learned single judge that, my lord, selection process is contrary to the, my lord, rules.
Para 5, page 22, my lords. Para 5, page 22. We were to do the selection in consonance with Karnataka Civil Services process of selection of candidates during Recruitment Act 2018. At para 5, the state submission is, we have not followed the procedure prescribed as against the 2018 Act. On this basis, the selection list was set aside, my lords. Para 5, page 22, my lords.
It's nobody's case that the judgment is erroneous.
Very much, my lord.
He is also asking, there is another vacant post
Indeed.
wherein you can accommodate both.
As far as my knowledge goes, my lord, there is no vacancy. All the posts are filled up.
Because
But how can we
the
do
post
this?
called was
Lords,
for
with great respect, my learned friend, senior friend, sir, was also there. Lords, learned AG was present. He had submitted, there is one vacancy and against which is called, but still not filled up, which is not
That is, my lord, fresh.
forthcoming
No, no.
forthcoming in the
My
order.
learned friend may not be right.
Our
Post
learned-
notified is, my lord, only 2. There cannot be.
notified
one
post selection has been made and the fresh selection list has
Our
to be done
learned
now.
advocate, Mr.
Sridhar.
For the appellant. From a learned additional government advocate, Mr. Chandrasekhar, for the respondent state. And learned advocate, Mr.
Satish came.
Satish, for original petitioner.
Please.
Respondent hearing. There shall be notice to the respondents. Returnable on 3rd April. The text of the case by interim. It is directed that
Not to prescribe.
that respondents irrespective of the status of the such select list, which may be opted to be published by the authorities, the services of the petitioner shall not be terminated.
Grateful, lords.
Yes. Lord, your lordship may clarify.
Here, we'll hear it.
Lord, your lordship may clarify that, Lord, the interim order will not come in the way of, Lord, appointing the respond number 2. Lord, they may construe that, Lord, there is an interim order.
If by virtue of this order,
Yes,
which you have passed in this language, if you are supposed to keep one post vacant, you have to keep it.
Please, Lord.
It is for you to interpret the order. We are saying that notwithstanding the status of the position in the new list is obtained, his services shall be continued till this appeal is decided.
they, not the, in that event, not in
We'll
that,
hear it when it is kept third. We'll hear it third.
in that event, my lord, state may not appoint me, though I am selected, my lord. Your lordship may clarify, my lord, that
3rd April is a short date, my lords, we shall close this here.
This is short as possible.
That's what I am stating before the court.
Yes, next.
Deeply obliged.
T5, TMC Basuraj. TMC Basuraj. 25.
Nobody is present. No, notice returnable. Delay, all right. Then keep it on 7th April.
Commercial appeals, seal number 26. Mr. G. Balakrishna Shastri.
For the caveat respondent.
My lord, there is a connected appeal which has to be connected.
Connected.
There's a cross appeal, please, my lords.
So you are for the respondent? Plaintiff?
Yes, I'm for the defendants 1 and 2, please. Plaintiff
1 and 2.
Yes, my lord.
You are for?
For the
He
plaintiff.
was for the plaintiff in the
Plaintiff, my lord.
court below.
Your appeal?
My lord?
It is your appeal.
No, my lord.
Yes, yes,
G.
please, ma'am. The
Balakrishna.
present appeal is by the plaintiff. The
There was a cross appeal filed by the defendants, my lord.
my cross appeal is in
So you are
2024.
here because part amount only you have degree.
Yes, yes.
And you are challenging the entire.
Yes, please, my lords.
Where is
On
your,
the jurisdiction itself.
where is your appeal?
My appeal has not been
Not
clubbed yet, please.
So both will.
It's
this
in
together?
court hall 2, my lord.
It was before.
It was present before court hall 2. It was listed
May
earlier.
pass on the
This is-
orders
Yes, my lord.
passed by
So
court.
It is 24.
Another was, it is a 24 of it.
Yes, my lord.
Oh. When this commercial appeal came up for consideration, learned advocates for both the parties stated that commercial appeal number 541 of 2024 preferred by original defendant 2 and 3.
1 and 2. Please.
1 and 2, arising from the very judgment and order of the court below, is listed before coordinate bench in view of the roster position with regard to the commercial appeals of the year 2024. Full stop. It was submitted that both the appeals, since arise out of the same judgment and order, judgment and decree, may be posted before 1/4 paragraph. The appeal shall be placed for orders on administrative side.
Twenty-seven. Mr. A. Mahesh Chaudhary.
Yes.
It's a commercial appeal, Milords, where the application under Order 7, Rule 10 came to be allowed on the ground that the concerned subject matter is not a commercial suit,
Commercial dispute.
commercial dispute. I'm sorry, Milords, I stand corrected.
Have just
The
been
con-
served a copy.
No, I just know, Milords may make the submission. There's an urgency.
Yesterday, my lords, if my lords may remember, I moved a matter day before, my lords, and my lords had given. After the cause list came, my lords, we got to know that they filed a K-wait. It was not for an office objection. We served a copy last evening. My lords, today morning we served a hard copy. My lords, the only thing, if they want to file objections, they want to argue, my lords, let them do so. The difficulty is that, my lords, the order is passed, which is at page number 44. Page number 43, the operative portion. A suit which is at the stage of further evidence of.
1 second. It was a joint development agreement in respect of what kind of activity?
It was a joint development agreement with regard to 5 acres of property, my lords. Co-joint development agreement. The issue is that, my lords, appellant before my lords today, that is me, my lords, is the original landlord, had executed a particular JDA with respondent number 2. Respondent number 2, without the knowledge of the appellant, that is my contention, had executed a co-joint development agreement with the respondent number 1, who's the contesting plaintiff before the commercial court. Based on that, they sought for a bare injunction or a permanent injunction, my lords, back in the year 2023. A suit for injunction came to be filed in the year 2023. After which, my lords, evidence was read, documents were marked. Finally, my lords, went further when there was an application filed by us for impounding. They come up with an application, my lords, saying that we are sorry, we just realized that our suit is valued according to the Karnataka Court Fee Act at 1,000 rupees. So there is no pecuniary jurisdiction. Second, it is a suit for injunction. Therefore, it is not a commercial dispute. The application gets to be allowed. The court does not consider the issue of specified value. My lords, may just pass one order. Today morning, my lords, when we were doing our research, we came across one judgment, my lords, where the coordinate judge, my lords, is a author of the judge. My lords, may pass it. Give it to them. Exact same issue, my lords, but with regard to the intellectual property matter. My lords, the only thing which I'm seeking, my lords, let them not go and take their plaint as what has been ordered. That judgment which my lords are looking at may take my lords directly to paragraph number 11, my lords.
But you have to prima facie show that it is commercial dispute.
It is. I will demonstrate it is a commercial appeal.
Falls within the definition of commercial dispute.
That is the observation.
No, it falls according to you.
Yes, it is a commercial dispute.
Section, commercial courts. So therefore, we were asking that what kind of.
Yes, my lords. The agreement which is at, my lords, if my lords may turn to page number 206, which is the co-joint development agreement.
206.
206, which is the sole basis of the
agreement is between you and the other side.
No, my lords. The agreement is between respondent.
Who are you?
I am the original landlord. I am the landlord of the property.
Party to the suit proceedings.
Yes, my lords. I am party to the proceedings. Yes, my lords. The suit for injunction was against me, saying that my right arises from a co-joint development agreement, which my lords are seeing at page.
Party to the joint agreement.
No, I am not. I am not a party to the joint development agreement. Respondent number 2, as my GPA holder, has executed it. Well, it's the issue whether co-joint development agreement is legal or illegal.
It was an agreement in relation to your property.
My property. My property, which is 5 acres of land, where a consideration of rupees
710 was filed by whom?
710 was filed by the plaintiff only. After 2 years.
Plaintiff only?
Yes. And that's at the stage of further examination.
What prejudice you are suffering?
Yes, that's what prejudice I'm suffering. It's twofold. Number 1.
It's plaintiff. It's his.
Please, that's what has happened here.
Dominus litis. Whether
the
plaintiff chooses one forum.
Yes, that's. I bow down, to the observation. But here is the question, could the commercial court could have returned the plaint, because the effect of returning of plaint, is the entire proceedings would start de novo. And whatever is contemplated under Order 7, Rule 10A is not followed when ordering. May look at the operative portion. the court has considered the entire suit. That's the
So
operative portion starts at page 43.
If this appeal is not entertained, then what will happen?
That's if the appeal is not entertained. That's two things. That's number one, the settled position that a co-joint development agreement issue has to be treated only by the commercial court will be upset. That's second.
That's all.
On the point of law,
You are in-
insofar as me, I am
in
concerned with, yes, Madad.
You are in possession.
Yes, I am in possession. I am in possession of the property is my claim. That's the effect which is going to happen to me is that that's the entire proceedings are going to start de novo, which means that's an IA for 39(1) and 2 came to be dismissed. That's an IA for 39(1) and 2 came to be dismissed. They will be entitled to refile it. That's the entire evidence would be taken on record.
Page 57, if your lordship sees, that would settle the matter. Page 57, if your lordship kindly sees. That is his objections that he has filed in the very same suit that has been dismissed now. At page 57, their written statement filed by them, this court lacks the jurisdiction to decide the dispute as the same is not a commercial dispute in terms of section 2C of the Commercial Courts Act.
I did
They
take up,
have themselves
but there was
said
no
it.
issue.
Then you can take up that contents in the suit which may be filed again.
That's again
And
it
your
will be
lordship,
filed.
what he's claiming, the agreement is between defendant 2 and 3, that is them, and defendant number 1, which is part of Art of Living, which is Sri Vision. Sri Vision is to take over their land and they have taken.
No, I
Now
don't understand where
now
this
I,
new
as
allegation is
Sumero,
coming from.
he is only involved in activities for Gurudev's any of these building or construction. What has happened is he has taken money from me and he's acknowledged the fact that defendant number 1 is through me taking the amount. Now I am not in their dispute. Both of them are in arbitration. Both of them are resolving in arbitration. I am only on the limited aspect of injunction.
That's it. That's it. That's it. Yeah.
The commercial court cannot host its own view.
We'll continue the hearing.
Please, please.
83.
I would.
All of the government order, my lords.
May I make a mention, my lord, if your lordship permits?
Lords, 83, my lords.
Can I make a mention if your lordship permits, my lord?
Criminal cases of my lords which government wanted to withdraw, I mentioned it the other day. They have filed the applications in many cases for withdrawal. The lordship may kindly take up today and pass an interim order.
My lord, may I
Lord,
request my lord to have it on Monday, my lord.
What is it about?
My lord, with regard to withdrawal of criminal cases, my lord, that
Oh,
have been,
that PIL.
yes.
Now
On
they have
Monday,
filed
my lord, I'm
application-
not,
Serious cases, 5 cases are closed. Therefore, other day I mentioned my lordship.
my lord, after the filing of the petition, my lord, only one has been done and that too, my lord,
I have
since
produced
they were
the
not
5 cases list
intimated.
along with the memo. Except a
But I
2-line
have-
application. and-
After filing of petition.
No, my lords, prior to this. January, they have done it and all the cases. they
Then we
filed
have made, I think we, if I'm not recollecting wrongly, we made some observation.
True, my lords.
We
Instead of
prevent them from withdrawing any case.
DP files 2 lines application and court would pass 2-line order. Without,
Then we have said in the order that
they have
will,
sent it, my lords, but many
will-
serious cases.
if will,
My lord, on Monday, my lord, learned advocate.
permits will take up today or Monday. Let us see.
Your lordship, this
Can I make a request, my lords? I'm sorry, my lords. Can I make a
Yes.
request before
Yes,
lords?
Mr.
Lords,
Yes.
serial number 95, my lords. Lords, this is the matter where the recruitment process is stalled, my lords. The learned advocate general had made a request for the matter to be taken up at 2:30. My lords, I am appearing for the impleading applicants. Lords, in the unlikely event of the matter being lords reaching today, can I request for Saturday at 2:30 minutes? I'm making the submission in concurrence with the advocate general. Saturday at 2:30 or Monday at 2:30 minutes. There is a grave urgency because the list is already finalized, minutes. The challenge is as to whether the negative marking should be done or not.
Milas, I appear.
Monday at
Milas, I appear for KPCL and on instructions of the Advocate General, Learned Senior Counsel is right in submitting that in concurrence with him, it's being submitted, Milas. On the previous date, Milas, it was actually.
There's an oral undertaking, my lord, before your lordship that they will not precipitate. Order sheet will reveal, my lord, that they have taken time, my lord. We are ready for argument on any day.
If you are insistive, then it can be kept on 22nd. But very slim chance of being taken up.
We'll still take the chance.
You will take the chance, all right. 22nd.
Lordship, might I request?
We'll take the chance. So grateful, lords.
Serial number
Grateful.
31. In fact, 10 days time, my lord, filed objection.
Serial number 21, my lords, just took it up. I requested the matter may be had on Wednesday, my lord. Saturday, there's some inconvenience. The matter may be taken on Wednesday, my lord. Serial number 21.
It is kept when?
Saturday, 22nd.
Second April. Second April.
Sorry, my lord, it was informed that 22nd.
Your Lordship, might I request in this matter tomorrow, Your Lordship, I'll have the objections also ready tomorrow, Your Lordship. So that they served us only this morning and last night we got I shall have the objections ready.
We will trace out some facts and keep it.
Please, please.
Serial number 36.
Serial number 36.
So you don't run away in the afternoon. We'll gather some facts.
No, I
and
have
then-
another 2:30 parted. That is why otherwise I won't.
Then tomorrow,
I'll make it.
we just try to make
Please,
it.
please.
If you want to keep it back, then we can
Please,
take up subsequently.
Please,
But we'll gather some facts so that tomorrow it is easier
please.
to take a decision.
Serial number 36 next week, Your Honor.
Lordships, kindly, your Lordship. Serial number 81 in the list today, your Lordship. This is a matter where we just moved an application seeking for a direction to the Justice Belunki's committee, G category committee, where were based on the orders of this honorable court, some inquiries were taken place regarding those particular allotments. Your Lordship, by your Lordship's order dated 5/7/2024, have stated that due to Justice D.V. Shailendra Kumar, who was the earlier chairman, being expired, only 2 members, who are the 3 members committee, to be continued with 2 members. There's an order which says that only 67 files to be inquired with. Later on, the BDA were to file some more files. By that time, later on, the BDA sends, and those applicants are before your Lordship seeking for a direction that 67, other than 67 also, if the files are sent from BDA, the committee could consider. Your Lordship order, if your Lordship pleases, the
That matter is again belongs to different bench, or now it will,
my lord,
that committee was reconstituted.
yes, my lord, yes, my lord. Your Lordship reconstitute the committee with only 2 members to continue with the inquiry. Now, my only request is my files.
Earlier bench it was possible.
Yes, my lord. Earlier bench had passed this order in the year 2012.
So what do you want?
My only submission is, my lord, that 67 files have been, my files which are sent now from BDA now are post your Lordship's order restricting the inquiry committee to consider only 67 files.
We have restricted.
Yes, my lord. Your Lordship can see the order dated.
So you are moving some application.
Yes, I moved an application seeking direction that the officers raised an objection that I was not a party in the writ petition. Hence, that's why it's come at serial number 81 in the orders for your lord. Yes, my lord. Only endure I'm at your Lordship's hands is that the application could be considered by the committee. The files which are later sent.
The main petition is disposed?
Yes, my lord. In 2012, it is disposed of with the constitution of 2 members, retired judges of this honorable court, and 1 IAS officer, retired IAS officer, your
81.
Serial number 81, your Lordship.
Just write down. This PIL is of 2010.
Yes, my lord.
It is pending.
It is disposed of. It is kept pending only for the reason to receive the report from the honorable committee constituted by this honorable court.
To be placed on the administrative side for appropriate orders.
Hello?
To be placed on the administrative side for appropriate orders.
Yes, my lord. One more. Committee's tenure is getting over on 28th of this month, my lord.
28th of this month?
This month, my lord.
We'll do something late, immediately.
Yes, my lord. Deeply obliged, my lord.
The kind leave of the court, my lord.
We'll take up all such matters. Or at least this matter, where wait for a day or 2, or by next week we'll take up.
Because my only request is, if 28th the committee's tenure gets over, even I will not be getting to even an opportunity to.
No, it will not. Let us see. Ask the Register Judicial to place these 2 dates.
Deeply obliged.
Kindly.
This should fall under the category of orders, not because there was an office objection from our side. The reply is not filed by the government. And so far as that is concerned, it's a contempt matter, where the order of this court in a contempt petition has not been followed. A notice was issued. That's I may request that to be listed any other day, not in the orders caption, but in the regular caption words.
All right. So it is for office objection?
It is not. The office objection is that they have not filed a reply to it.
All right. Which one?
74.
This is not in an order caption.
Non-filing of reply notes. When it's come as orders.
Contempt petition 242/25 shall be listed on 1st of April. Next week will be difficult. 1st of April. In regular listing. In the list on 1st of April. It is listed regularly only, not under orders.
That's listed under for non-filing of reply methods.
Come under the category of orders, non-filing.
Non-filing.
Shall not be listed in the category of orders not filing, but in regular course on 1st April.
Serial number 31, my lord.
One
I'll
second.
seek
1 month. 31.
31. I'll play 10 days time.
Will go beyond.
Please, my lord.
My lords, but in the meantime, our application for impleading A3 might be allowed, my lords. Appellant number 3, my lords. It's the state's writ.
No, for that, all the things I am going to file objection. I'm going to file objection for that. I'm seeking
Layman will issue notice or
Very much more.
notice returnable on 24th of June. In delay.
Serial number 36, you are 1 week time. 36. 36.
Yes.
1 week when paid.
June. 10 to 24th June as requested.
Much obliged.
My lord, serial number 102, my lord. Kindly grant week's time, my lord.
102. Need time. By 10 to 23rd June as requested.
The kind leave of the court, my lord. My lord, serial number 95, my lords. The AG has requested, your lordship had posted it for Saturday at 2:30. The learned AG has requested it to be posted on Monday, my lords. He has also spoken to learned senior counsel B.R. Ravi Shankar, who had made the submission, my lords. He is also okay with Monday, my lords. May I request to be posted on Monday?
My lord, I appear for the appellant in 95.2. Lord, we are being led by a senior advocate. There is some inconvenience on Monday, my lord. May I request your lordship to have it on Wednesday, my lord?
Very well.
95. What is the matter?
My lord, it's the
relates to
recruitment
of
notification, my lords.
engineers in the public, sir. Karnataka Power Corporation. There's an oral undertaking, sir, that they will not create third party.
My lords, the urgency is, my lords, that the final list is ready and appointment orders are ready to be issued. Hence the urgency, my lords. Hence I request the date may be fixed, my lords, for next week. Wednesday is okay, my lords. Monday preferable, but if learned senior counsel is not available, then Wednesday is okay.
Wednesday, please. I would request. 26th.
Of course, subject to your lordship.
Better 2nd April. 2nd April.
My lords, that would be too long a date, my lords. I request to be posted next week. Learned AG is requested, my lords.
No dire urgency to keep it on Wednesday or Monday or.
My lords, the thing is, for 622 posts, 18,000 candidates have written the exam. The appellants before this court are only 10. For that, my lords, the entire thing has been stalled. The final list is ready to be published, my lords, and appointment orders also are ready to be issued. But because of the undertaking of the learned AG, my lords, we are unable to proceed. If your lordship would kindly take it up next week, my lords.
27th.
Grateful.
Grateful.
Serial number 27.
Serial number 91 and 92. Two weeks time is granted. 3 weeks time is granted to remove the office of justice. Failing with the writ appeal shall stand dismissed automatically. Reference to or order of court. Same, but separate.
Serial number 27.
Because of the way the transaction is structured, just give me the two. The list of dates. That I made a list of dates here, which probably would help parties as well as the court minutes. That's the appellant is the
owner is the landlord, my lords. He's the owner of the land. That's
See, they are the plaintiffs.
yes.
You are one of the defendants.
Yes, my lords.
They have withdrawn their suit.
Yes, my lords. They have withdrawn the suits.
Wherever they file, you go oppose there. If that
Right.
court has no jurisdiction, then you take up that contention there also.
That's my only grievance is that, my lords, if my lords may see the list of dates for a moment.
Why should we go into it?
I
It's
tell
not a
you, my lords.
partition suit. You're not.
My lords, I may just
You're not a
request.
plaintiff over here. You're a defendant.
Yes, my lords. May I make this submission, my lords. In page 2 of my list of dates, my lords would get certain applications which have been filed by the plaintiff, certain applications filed by the defendant number.
See, all those things comes to naught once they withdraw the plaint under 7 Rule 10.
And my lords, that written of plaint under 7 Rule 10, my lords, is not proper is what my contention is for 2 reasons. Number one, my lords have asked how I'm getting affected. My lords, the entire proceedings would be started de novo. There's already an observation that they are not entitled for an interim injunction till the disposal.
Take up that contention before the
That's
court also.
That's the law on that point, my lords, is that whatever
It was 710 was filed at what stage?
710 was filed at the stage of further evidence.
No, hearing of application.
No. My lords, look at it. It was at
The suit was at what stage?
the suit was at further evidence of plaintiff along with.
CPC. I think we think that it can be done at any stage of.
Precisely, my lords, it can be granted. That's my exact grievance. Now that, my lords,
Your Lordship, the Honorable Supreme Court in that has held that even if it comes to the stage of final arguments.
my
it
qualm
if
is not
it
with
is
regard to
court
my.
at any
lords,
point of time, the plaintiff.
I
can
am
withdraw
not.
the
I am
suit.
not saying that, my lords, the court could not have returned the plaint for a moment also at the stage of evidence. That is not my grievance before my lords. The grievance before my lords is that, my lords, the stage. My lords had asked a question. What stage is it? It was at the stage of further examination in chief and an application for impounding of their co-joint development agreement. At that stage, my lords, they come and they file this application. Now, my lords, what is the inconvenience or what is the grievance of the appellants before my lords is that the grievance is that, my lords, they had filed an application under Order 39(1) and 2, came to be rejected. They filed a commercial appeal, which is pending today before this Honorable Court. Number 1. Now, my lords, if I go back and everything starts de novo, my lords, the law on the point is that, my lords, whatever finding which is being made by this court cannot be used there. And my lords, if at all I have to be suffering another order, and virtually it would amount to forum shopping, my lords. That is number 1, my lords. That is the grievance I have. But my lords, on the point of law, if the plaint could have been returned at all, the answer to it, my lords, respectfully, my lords, the trial court has held in both point of law with regard to the specified value, as well as, my lords, the concept of commercial dispute as envisaged under the Commercial Courts Act. My lords, this is the point of law and before my lords, that written of plaint, as much as, my lords, they could have withdrawn it. They withdraw it only at the stage of evidence. That is the factual position. But the return could not have been granted because the reasoning given by the court is that it is not a commercial dispute. That is the reasoning given by the court, my lords. That, my lords, it's a settled position by this Honorable Court in more than 2 judgments or 3 judgments, my lords, that an agreement which relates to construction and infrastructure, my lords, is nothing but a co-joint or termed as a joint development agreement, MOU, or co-joint development agreement would become a commercial dispute. If that being the case, my lords, I am only of one point. Ask myself, tomorrow, my lords, there'll be a situation where it's about, they may understand that, my lords, in their cross-examination, they have not performed or they have not delivered the answers which should lead to a dismissal of the suit. They come and file this application, my lords. Now, my lords, where would the defendant go who has conducted the trial for such a long time? there's an erroneous observation on the point of
An
commercial suit.
observation that you can take up all contentions in the code where they intend to present the suit should suffice your interest.
That's that's may take my lords to, that's my lords had asked for the facts.
You are the defendant.
Yes, my lords, I am the defendant, but I have to redo the entire trial process, my lords.
But institutes a suit. Then says to the court, I don't want to pursue before your court. Please return the plaint, because in my perception, this suit will lie in a different. Court agrees to it. Returns the plaint. What role defendant has to play? You go there whenever you are arraigned as a party defendant and raise all contents.
My lords, such a return could not have been granted by the commercial court, my lords. My lords, can I rely upon one judgment? I took 3 copies. That's a precise issue. 2 copies. Precise issue, my lords, came up before the court, saying that, my lords, a commercial, my lords, first and foremost, my lords, I want to lay down before, my lords, my submission, my lords, that number one, the dispute between.
You tell us how, in what way you are prejudiced or any
Lords,
right is infringed.
in that event, my lords, I would, my lords, that would be.
You are saying some finding is recorded.
There's a finding recorded.
The finding recorded.
The finding recorded is that they are not entitled for an injunction order, my lords, under order 39, 1 and 2.
Very good.
Please, my lords, that observation, my lords, now by the virtue of written of plaint would be diminished and everything can be taken up freshly by the plaintiff, which, my lords, would be like having suffered an order, they go there, file another application under 39, 1 and 2. My lords, the real loss is the way I would term it, my lords, respectfully, as forum shopping. My lords, they come at what stage? And my lords, even the law on the point, my lords, can a code development agreement be ever called as a commercial dispute? The answer to it is yes, my lords, as held by this honorable court in more than 2-3 occasions, my lords. The second point is that, my lords, their contention, the reason, my lords, for seeking of written of plaint is that my suit is valued for the sake of injunction at 1,000 rupees. Therefore, you have to take that value for pecuniary jurisdiction. That's that also, my lords, I just submitted a judgment before lunch, my lords, that the specified value is qua the subject matter, my lords, and not the qua the relief sought, which my lords have held it at paragraph number 12, last 4 lines, my lords. And in this particular situation, my lords, if the written of plaint is allowed, my lords, I do not, my lords, I'll make the submission, my lords. I don't have any problem in going to the city civil court. I have no problem, my lords, I would. But, my lords, it cannot be in the nature of written of plaint. It cannot be in the nature of written of plaint, my lords. There was a notification, my lords, which we are not in a position to get hold of, dated 14/2/2022, my lords, where all the cases which the commercial court felt was not in the nature of commercial dispute was placed before the PDJ, my lords, and they in turn had allotted courts in the city civil court, my lords. I have no objection to go to city civil court or any other court, my lords. My only grievance is that, my lords, I have to restart the trial all over again. And they will have the benefit of, number one, my written statement, number two, my objections, and the stance which I have taken with regard to impounding, my lords. Today, my lords, if written of plaint is granted, their application or their document also could be returned. Now, my lords, they will avail their remedy and they'll come back. And, my lords, I will be at a loss, which otherwise they today, my lords, are fighting before the court on the same point. There are 4 IAs which are pending.
You are trying to submit that they have taken some advantage.
Yes, they are going to take advantage and they have taken advantage.
Going to take a different.
My lords?
The advantage.
No, they have, my lords.
What advantage?
They have taken.
They have not get any interim injunction.
They have not got it before the commercial court. And the commercial appeal is pending on that particular IA.
By you?
By them.
That's withdrawn, your lordship. That's
Also,
No, I don't know when got withdrawn.
will
But
also go once order 7 rule 10 is implemented. Appeal will have no efficacy.
that's The question, my lords, the larger question, my lords, if my lords may permit me to say, keeping aside what would happen to what is my grievance, my lords, in law, the written of plaint order could not have been passed. May I take my lords to the order, my lords, at page number 43. My lords may permit me to do so. My lords, small indulgence, my lords, I will demonstrate to the court as to the logic and the intention of the trial or the commercial court in allowing this application is not founded, my lords, in the four corners of the law or the judgments which have been pronounced by this court or any other court, my lords. May permit, my lords, to take 3 paragraphs of the impugned order. The impugned order would start at page number 22, my lords. From page 36 onwards, my lords, the reasoning would start. In substance, the reasoning, my lords, between paragraph number 22 to 24 is that, my lords, a suit has been filed by the plaintiff seeking a permanent injunction against the appellant before, my lords, with regard to a scheduled property owned by the appellants. And the suit is valued at 1,000 rupees because it's a suit for injunction, my lords. Section 26C of the Karnataka Court Fee and Valuation Act would be applicable, whereby they've paid 25 rupees as court fee. Now, whether it's the second, that issue is not being dealt at all. But the trial court goes on to the observation saying that the commercial dispute, then, my lords, the only thing, my lords, which happened even before, I'm even, my lords, citing a date, which I'm not able to get a notification because I did inquire in the commercial court even few minutes ago.
Virtually by observing that the other court will be entitled to consider or shall consider and will be entitled to raise the contention that this is a commercial suit, not a regular suit. So by observing that, we are nullifying this order in your favor. But no other relief we can grant.
Let's make a final attempt saying one thing, my lords. Well, I'm grateful, my lords, that observation may come in my favor if the judgment which I have just placed before my lords.
Will Madam observe that he will be entitled to raise contentions, including the contention jurisdiction.
All contentions are left
That's
open,
right.
that's all.
Fair enough.
And methods, may I request one more, if methods, only in addition to that methods, including the observations on orders passed from the IA's methods, which even they have got one benefit of it, I have got a benefit of an IA. It's methods. I'm only saying that methods, if all contents are left open, even with regard to jurisdiction methods, even the observations otherwise passed by this court, I should be in a position to plead before the other court.
The present suit goes out of the jurisdiction of the commercial court. Nothing will survive. No pleading, no plaint, no written statement, no finding. It is entirely the other court where the plaint will be presented will consider the
Let's let the evidence be
that
considered.
your plaint will be sent.
Order methods, but
No,
at the
you are
same
not
time,
Don't believe that any order is given.
no, methods, I'm only saying that methods at least,
Change it.
no,
We might change our mind.
I stand corrected, I stand corrected.
Even after
I'm
completion of
sorry,
the order.
I'm sorry. Methods,
I'm
I
every
stand
day telling that don't rely on your judges.
corrected.
Most fragile. Till we sign it. And I am so throughout my career. I never bound myself. Yes. Proceed.
That's yes. The thing is that methods which I'm very concerned about the way the plaintiff has conducted himself. The very JDA methods which I'm contesting, saying that is a non-existing JDA method. Now, based on that methods, if they obtain an order 13 and 1 and 2, I'm already.
We are on the very first principle and the basic concept. We are not able to accept your appeal or plea or contention or whatever.
That's in that event, methods may request that
Withdraw.
methods. Methods. No,
We'll give liberty. We'll give
methods,
liberty you to.
it may be
raise all
disposed of with the liberty is what my request is. It may be disposed of methods if the liberty stating that methods I may be entitled.
Say that you don't have the locus or you have no right to challenge since defendant. You can raise all contentions before the court where the plaintiff may be present. That's
Including the issue of jurisdiction.
all is all.
That's one inclination.
There is nothing.
That's
There is nothing
inclination.
adverse to you, Mr. today. So that's the whole thing.
That's in that.
Better you withdraw and
That's may.
raise all rather than we dismiss it. Our dismissing it will be a different connotation. You can withdraw it. Either will record your request and grant that request.
That's another thing, methods, which may require methods intervention to modify the order is because methods, they've just returned the plaint. They have not set a time or a date on which the plaint should be presented before in terms of order 7 rule 10B. And methods, that has to be interfered with. That's my request. Under order 7 rule 10B methods, if the case is progressed to after the pleadings methods, then methods, when the returning of the plaint is happening, the court, whichever court is passing the order, is bound to set a date and a time upon which the party, that is the plaintiff, would go present the suit, which means methods, it's also recorded that I don't notice need not have to come. Methods may look at order.
Your Lordship has already filed a caveat in the civil court, so that anyway.
Notice will not be issued. That's the law. I may
Question
file
of
caveat.
notice won't arise. He's
It
already
may not
filed a
arise because
caveat.
I don't have, there's no concept of issuance of notice.
Is it a ground of your challenge here?
It's also a ground of challenge that it's not complied with. 10A.
No.
10A is not complied with. The order is back. Insofar as that, at least my lords may interfere along with my lords when I'm asking for the liberty. That's clause B, my lords. Specifying the court in which he proposes to present the plaint after its return, praying the court may fix a date for appearance of the party in the said court, and requesting that the notice of the date so fixed may be given to him and to the defendant.
That is all procedural.
And
Please,
it's
my lords.
not yet returned, Your Lordship.
It's not yet returned. that order should be passed by the court itself, my lords. That's there.
Application made by the plaintiff, read the provision properly.
Please, my lords, power of the court to fix a date of appearance in the court where the plaint is to be filed after its return. My lords, when an application, my lords, merely because, my lords, the plaintiff did not invoke this particular, it's, you know, it's mandatory, my lords, they do that because, my lords, today if it goes.
Maybe asking this prayer is adverse to your interest. Think over once again. If this is done, then you cannot raise the jurisdiction of the other court in your fresh.
That's in that event, my lords, may. What my I'll withdraw this, my lords, with a.
That's a wiser
liberty.
thing. That's a much wiser thing.
Nine SCC 435. Where's our item? Switch on the Wi-Fi.
So this is an application by you?
It is an application by the
Which provision?
plaintiff. Under Order 7, Rule 10 of CPC.
By them, sir.
By them,
10 or 10A?
10 minutes.
10.
Ideally, they should have filed it under 10A methods, but they filed it under 10. The application is at page number 192.
Present commercial appeal. Before the competent civil court, namely the Principal Civil Judge Court, Bengaluru Rural District, Bengaluru. In course of the
That's including jurisdiction.
They
That's
might come up in appeal on that.
no.
Aspect may not be available in law to be done. So still we are taking out all contentions.
That's all contentions again. That's as raised in this appeal. That's maybe.
See, you should not be arguing these aspects at all.
That's
The
knowing
way you are
plain text.
arguing as though like comma, full stop, everything that we have to write and give.
That's not that.
It's not that the trial court cannot understand plain English. We find, I don't know why this practice has crept in with so many advocates, even when we remand the matter back to the authorities concerned, they want certain words to be put in. They can't understand plain English means we can't help it. When we say all contentions that is available to you in law, what else do you require? If it is available in law, you take it up. If it is not available, you can't take it up. You convince the court concerned.
Great for this.
My lord, a little earlier, my lord, I can.
Little earlier. And 7th April.
Lord, it may not reach now because it's on the first, and if the survey is done, it will be
My lord,
taken
if
up
the
on first.
respondent number.
Let us see on 7th April.
Please, my lord, please. Much obliged.
104. The Sundaram Gimbi.
The petitioners in this case, the respondent had filed an affidavit to say that this petition is now infructuous, my lords.
Appear for the respondent number 2, man.
My lords, we are only pressing for our prayer number 3, which is a foot overbridge in this matter, my lords. My lords, I had filed a memo dated 12/2/2025, my lords.
So you are saying it is infructuous, or they are saying.
My lords, we had taken up the construction of this underpass, my lords, which is complete. As of
Your
today,
rail-
we filed the affidavit.
Your
also.
railway,
Railway. my lords.
so it is complete.
That is complete, my lords. I filed the affidavit along with the pictures.
What is the prayer in this petition? Demolition.
My lords, there are three
So now what's foot bridge? Yes, what do you say? What? Now it may not-
Today there is no traffic restriction, my lords. The movement is smooth. So,
my lords, the footover bridge is only for pedestrians, my lords. It has nothing to do with traffic. per
Now
se.
we don't think it will be possible after construction is over.
construction is over, my lords.
There is an underpass there.
Yes, my lords.
That takes care of pedestrian needs. If there is clogging of water during monsoon season, you should ask them to see to it that the water is removed from that place. You can't have an underpass as well as foot over bridge at the same place for the same purpose. Underpass is created for pedestrians, right?
Yes, my lords.
Also. Then
My lords, if there's any direction to that effect to the respondent. My lord, there is complete clogging of water. There is absolutely no.
where have you said
possibility
that in your writ petition about clogging of water? Where have you said that?
I haven't taken that
Then-
contention, my lord, but I've also produced photographs. I can file it by way of an affidavit, my lord.
You can't improve on your writ petition like this. Foot over bridge also, the existing underpass also provides for pedestrians to move, right?
Yes, my lord.
Please, my lords.
Yeah, that takes care. I think if the citizens are enlightened enough not to throw anything over there, it don't get clogged.
The present writ petition was filed as public interest litigation in which the petitioner prayed for restraining the respondents from carrying out the demolition of and thereby demolition and thereby preventing and from preventing from carrying out demolition and from preventing ingress and outgress to the KR Puram railway underpass from FCI Go Down Road, Bengaluru. until reopening of the alternate road through Kempegoda underpass on the Kempegoda underpass road. The second part of the prayer paragraph was to restrain the respondent authorities from placing any material or otherwise so as not to obstruct flow of traffic through the K.R. underpass. The third prayer was to direct the respondents to provide a foot overbridge over the underpass. Full stop. The grievance arose for the petitioner. As the respondent railway authorities had initiated the demolition of the construction activity for constructing the railway underpass. Notice was received by the court in the petition. Full stop. Today when the paragraph. Petition comes up for consideration. Learned Advocate Miss
Reshma Tamayam.
Reshma so invited attention of the court. So assisted by whom?
I'm great.
Learned Advocate Reshma assisted by or other
Whichever.
learned additional solicitor general. Kama assisted by learned Reshma. Invited attention of the court, affidavit filed by them, in which it is and the extension work was carried out with coordination of the authorities, including the Bangalore Mahanagarpalika, the traffic department, and other authorities, and that no untoward incident had occurred at the place, at the site. Full stop. The underpass paragraph. In view of above, hardly anything survives in the present petition. Full stop. The underpass in question, constructed by the railway, itself serves public purpose. Full stop. When the traffic movement is shown to be smooth and unhampered, no case is made out to grant any of the reliefs prayed in the petition. Is this for?
Great.
This was what? Now. Eighty-three is PI and 97. Okay. I don't think we have time. Half an hour, 45 minutes. Length.
This number 83. Mr. Sridhar Prabhu, Venkatesh P. Dalwar.
My lord, could I seek for a short accommodation till Monday?
The memo is filed by me to say that, my lords, in January, certain cases are closed by passing two-line order. And the prosecution has filed an application in the Hubli Rights case, which your lordship would kindly see the application itself along with the memo.
So I don't have a copy.
No parameters of the apex court has been considered, except saying that, my lord, please take page 1.
The Dalwai, I don't have a copy of the memo.
Madam, put it. It's served. You see the memo, page 1.
Where is that memo?
My lords, I have filed it on 15th of March.
15th of March.
Yes.
But day or two will not make any difference. 15th of March, there is no memo.
My lord, it's filed. Same it was put up.
15th of March.
Yes.
Yes.
My lords, may I request page 1, your lordship? Page 1 of the memo. This is the application filed for, my lords, in a case where 154 accused who ransacked the police station, assaulted police. This is the application, except quoting, my lords, the order impugned in the writ petition. Nothing is there. And if your lordships were to kindly see the page 5.
Application is filed, then we have observed something.
True, my lords, by interim order, your lordships have clearly indicated. But, my lords, despite the order, in fact, page 4, the prosecutor's opinion is not taken. That is also confirmed in the
This
correspondence.
application is filed when?
Lord, it was filed prior to your lordship's interim order.
That is why.
There is no dispute about it. But in spite of that, my lords, in January, around 5 cases are closed. All I am requesting is, my lords, the order may be kept in abeyance because the prosecution department will go on filing all the applications. And look at the kind of order, my lords, which is passed. At page 8, page 9.
So when do you?
My lord, Monday, my lord, may have this on me. Because Learned Advocate General is not in station, my lord, may have this on Monday. Tomorrow is Friday.
Monday.
Monday.
May I request 2:30 since
We'll
AG is
take
also.
Today we have taken up. On
Great.
that day also we'll take.
Very great.
Obliged.
Cell number 97, Mr. Naveen GS.
Yes.
Here for the respondent number 1, my lord. I am the contesting respondent, my lord.
You are respondent.
It is the matter relating to the
You are respondent.
first respondent.
And where
I have
is-
filed the application, my lord.
Where is the other side?
Please, my lord.
Naveen GS.
This is regarding some election.
Please, election to the post of treasurer of the Bengaluru Advocates Cooperative Society, my lord. There is an interim order of this honorable court on 8/8/2024 that the elections shall be held as scheduled because already the calendar of events were announced. And the election was scheduled on 9/8, very next day. So the election was held, my lord, but the results shall not be announced without the permission of this honorable court. That's the reason to declare the results, my lord. And another election for as an internal arrangement for the post of office bearers is scheduled next week, my lord. My nomination was rejected. That was challenged in the writ petition. The writ petition came to be allowed. The election was set aside and there was an order to conduct a fresh election between me and the appellant. And it was conducted on 9/8. The post of office bearers, my lord. And this election is held, but the results are not declared.
So you want to contest the next election also?
I'm not even supposed to contest, my lord, because this matter remains untouched, Yakendra, because the results cannot be announced, but the elections are over.
No, what is the urgency about this matter?
My lord, urgency is this, that since from the day one, though the election is set aside, is continuing by virtue of the order of this honorable court. Without declaration, he is still continuing, my lord, because there exists a lack. Now, if he is removed from that office.
The last of
I think,
25th.
my lord, let it be listed for hearing on IAS, my lord, that's my, because it is listed for final hearing. If it is listed for IAS, then in the natural course, it will be
Listed for
25th of this month, my lord. Please, my lord, for hearing on IA, my lord. Sir.
This is Nyamitra Cooperative Society Bank.
Name it, not Nyamitra. Advocates Cooperative
Yeah,
Society.
that is running Nyamitra Bank. No, is it running that Nyamitra?
No, not Nyamitra Bank.
That's a separate
That
thing.
is separate. Your Lordship, I'm sorry, my lord, I was late. It involves a very short question, my lord. Your Lordship may for a moment have a look at Rule 14AG of the Cooperative Society rules.
But in absence of other side, I will consider. Where is the other side?
Of course, my lord.
The only handicap. That is the handicap. We will consider, but not be able to finalize it.
I was not a member of it, right?
Nyamitra,
because I was.
Nyamitra is a separate this thing. It is a society in the name of Nyamitra itself. Rule 14AG.
Bangalore.
A, capital A, capital G.
This is different.
14 AG 1 provides the returning officer who has conducted the general election shall also be the returning officer for conducting the office bearer selection. Then, my lord, kindly go to sub rule 4. Not less than 2 hours before the time fixed for meeting for the election of president or vice president or any other office bearer, any member of the board who is eligible and desirous of being elected as president or vice president or any other office bearer as the case may be, may submit his nomination by delivering the nomination paper in form number 14 to the returning officer. Such nomination shall be proposed by another member of the board eligible to do so and seconded by the third member of the board eligible to do so. Now, sub-rule 5. No director shall propose or second under sub-rule 4 more than one candidate for the office of president or vice president or any other office bearer of the society. That is, for each of the office, he cannot do more than one. What the returning officer now does is, he rejects our nomination paper on the ground. Your proposer had seconded a nomination for the post of treasurer, president post, for the post of president. Learned judge has pointed out, for each office, it's a provision. You cannot extend it in this manner saying, for president you have proposed, therefore you cannot propose for another office. Actually, election was called for. Therefore, your lordships, while passing the interim order, also said, let the election go on.
They're arguing the main appeal.
That would be the only thing. No, why we moved it is, your lordships had directed that election may be completed. Don't announce the result.
We can slide the other side.
Please. ಏನಾದ್ರು ಬರ್ತಾರನೋ ನೋಡ್ತಾರ.
This is number 28. It's a review petition by state. The review petition by the state, my lord. There's a delay of 104 days, my lord.
Delay.
There's a delay of 104 days, my lord.
Notice returnable. 17th June.
It's number 29. 29 also, my lord. 111 days delay.
19th June.
19th. It's number 30. Commercial appeal.
This case, madam. Kindly pass over. We have engaged senior counsel Udaywala. He's on his legs.
Passover will not be possible. Stand out.
My lord, he's coming, my lord.
Not possible. It's not possible. 11th of June. Yes, next.
31, 32. Our urgent number 33.
33.
Phone number 3 and 4, my lords. In the last occasion, I was directed to file my objections to the IA for continuation of delay. I have filed, my lords, it is put up. My lords, IA cannot be condoned according to me. The reason being is this.
Delay of 106 days.
106 days, my lord. My lord, this afternoon I came to know that the appellant is no more. This is what I heard. I am not sure. I will ascertain and make my submissions, my lord.
We keep it on 2nd July, 2nd April.
April.
2nd April.
Very well, my lords. Much well.
Number 34. It's a state appeal.
Appear for the respondent.
This benefits of regularization is available after how many years?
My lords, just a factual background, my lords, I'll just take a few minutes. From 1980 to 88, these were daily wage workers working under the archaeological department, my lords.
Which department?
Archaeological department. So at 88, the department refused work. So there were two industrial disputes raised, my lords. One is seeking reinstatement in work. The other is the regularization, my lords. The list attained finality. The dispute, there were twofold this thing, my lords. Twofold industrial dispute raised by the workmen in the 1990s. Telling in the first dispute, they wanted the work to be given back, stop the contract system. The work to be given back to them and the contract system had to be stopped, my lords. The second is also similarly placed wherein they sought for reinstatement, my lords. The tribunal in both the disputes ruled in their favor, my lords. Page 64 and 75 is the operative portion of the awards, my lords. One, in the first award, they told the work is to be given back to the workman. Second, we were instructed to stop contract system. Third, to maintain seniority list. In the second award, we were directed to reinstate, my lords. This list took up till November 1999 for us to reinstate, my lords. Both the industrial dispute awards were challenged by the state in writ petitions. We failed in both of the writ petitions, my lords. Then we took it up under writ appeal. There also the state failed. Ultimately, we went up to the spot, gave them the minimum wages as applicable under the PWD department of the Bellary district, my lords. So with regard to the payment of minimum wages, there is no dispute as of such. Now they came up with a representation telling, give us the differential wages under the beneficial enactment, my lords. The beneficial enactment is found at 127, my lords. 126 is the title. The Karnataka Daily Wage Employees Welfare Act 2012, my lords. Now, if my lords were to take page 127, in the definitions, my lords, the definition 2A would be the relevant portion as such, my lords. The daily wage employee means an employee engaged by the government or local bodies on daily wage basis who has worked and completed not less than 10 years of service as daily wage employee as on 10th April 2006 and who is working as such on the date of commencement of this act. Whether these respondents come under this said definition is the list under before my lordship's consideration. Thereafter, the respondents gave us a representation seeking them to be considered under this beneficial legislation. We didn't consider the representation, so a writ was filed, a mandamus was issued for us to consider the said representation, my lords. Upon the mandamus issued, we have considered the representation vide our reply dated 27/6/2023, annexure Q, my lords. On twofold reasons, my lords. On only one relevant reason, my lords may kindly take to page 154, my lords. The last two paragraphs, my lords. (153) is the vernacular portion. The translated is at page 154, my lords. As per the Karnataka Daily Wage Workers Welfare Act 2012, the daily wage worker means as on April 10, 2006, as daily wage worker should have continued to work not less than 10 years and completed the service and the commencement of this act. On the basis of daily wage working, such employees should have engaged in government or local boards. Since the said daily wage workers had joined the daily wages service on 31/8/99, final judgment of industrial tribunal dated such and such, had not completed 10 years of service, there is no provision under the Karnataka Daily Wage Workers Act of 2012 to notify them as daily wage works under the Act.
Here they have completed 10 years service.
What we did is, my lords, we didn't take the earlier service into consideration, my lords. We only took the reinstatement date as on 19/9 to May 2012 as the date, and we told that 10 years of service is not completed. If the earlier period from 1980 to 88 is taken into consideration, then they would have completed the 10 years of service, my lords. This is the stand of the government, that on the date of reinstatement, they are not completed service, my lords. One more.
See, look at
2A definition would be relevant, my lords.
Now, after reinstatement, you are treating them as daily wagers or salaried employees? Per month you are paying them?
My lords, before I go to that point, my lords.
Daily wages only.
Daily wages only, sir.
Daily wages only. And similarly placed in Department of Sericulture, there is a order which we have suffered on similar circumstances. As an officer of the court, I'll just point out that also, my lords. Page 136, my lords. Page 136 is the order, my lords. This pertain, page 138, this pertain to workers working in Commissioner for Sericulture, my lords, under the Department of Sericulture. And para 10 may be kindly looked into, my lords. A perusal of the award passed by the Labour Court would clearly indicate that Labour Court has directed that the petitioners to be reinstated along with the continuity of service for all purposes except wages only. So also the learned single judge in WP number such and such and connected matters, as well as Honorable Division Bench in WS such and such, have categorically held that the petitioners have worked for more than 10 years during the period from 1985 to 89 to 99. The material on record also indicates the specific contention of the petitioners that they were employed as daily wage employees during the period from 85 to 89 onwards is not in dispute. In view of the court orders referred to supra, merely because the petitioners were terminated from service and litigation was pending between the petitioners and respondents, as on the date of coming into act from 15 to 2013, the said circumstances would not come in the way of petitioners claiming benefit under Section 3 of the Act of 2012. Here, even though breakage of service was there, it was treated cumulatively as 10 years. If my lords were to uphold that view, then the petition doesn't survive. Appeal doesn't survive.
In that case, they have implemented minutes. They have issued a gazette notification and implemented.
I took time to see if we have filed any appeal. It's not forthcoming.
Yeah. Gazette notification. They have implemented also.
The learned citizen has pointed out that on 6/2/24, we have implemented this order, my lord.
this order at page and page 136 is what?
127.
136 is pertaining to a different department of the government, my lord.
But
Department of Sericulture, my lord. This is the archaeological department.
Same issue, minute.
but they have lost. They have succeeded.
Now on 6th of February 2024, we have implemented the order is what is forthcoming from the circular just passed on now, my lords. I'll just pop on to the
Same benefit is given.
Same benefit.
same benefit is
They
given.
have brought under the Welfare Act.
That is implemented
Yes, minute.
That's what is forthcoming now, my
on
lords.
They have issued a gazette
6th of
notification,
February
minute.
2024.
which one? 8th February.
6th of February 2024, my lords.
Put up. Sorry, minute, it is in Kannada. I didn't translate it. Sorry.
Dismissed, my lords.
That's it. For implementation time frame may be fixed, minute, because they are waiting for almost 12 years, minute.
So what benefit will be given? Within 12 weeks?
Within, my lords.
12 weeks.
12 weeks. Weeks, 3 months, my lords, we have been fair to
That's
the,
all.
3 months,
12 weeks,
my lords, 3
almost.
months.
So it is as good as time to appeal.
Very much.
December 35.
And the appellant, my lord. The appellant was working as a driver cum conductor, my lord. Driver, son. He was working as a driver cum conductor in the Northeast Karnataka Transport Corporation. He met with an accident on 13/2/2016 and he sustained disability, permanent disability to the extent of 56% locomotive disability. So he lost control over both the limbs, lower limbs. So he was provided with lighter work for 6 months. Then he was subjected to revaluation of the medical examination. There, another certificate was issued that he has no disability. Then this driver gave an application, representation to the respondent number 4, who is the quasi-judicial authority, commissioner for disability persons, rights of the disability persons. Then after hearing both parties, the commissioner moved the government for the third report. So third report, the district board, medical board, gave a report disability, permanent disability, discharge his earlier one, and therefore he should be given lighter work. So then the KSRTC, that is the respondent number 1 to 3, was the management, directed the appellant to attend the previous work. He could not attend the previous work. Therefore, now the challenge, the respondents 1 to 4 challenge the report of the order of the respondent number 4, that is the commissioner for disabilities, on the ground that the second report says that there was no disability. Then respondent number 4, commissioner should not have ordered directing response 1 to 3 to provide light work in view of the third report. So this third report was in view of the second report. Third report was not brought to the knowledge of the learned single judge. Therefore, I could not bring this certificate, third certificate, to the notice of the learned single judge, my lord. So now he has been, they are, he could not, as he could not attend the earlier work. Now he has been, departmental inquiry is being conducted. A charge sheet has been issued why you are not attending the duty as per the decision of the learned single judge, my lord. Therefore, I am seeking, earlier there was a delay of 32 days. The delay has been condoned by this honorable court. Now I am seeking the stay of the judgment of the learned single judge so that the departmental inquiry can be stopped at this stage, my lord. He can't attend the driving work, my lord, because his eyesight is also has been affected. He has no control over both the lower limbs, and therefore he knew of the third, and this is the final report. Medical board, this is the report of the medical board, district medical board. It is a final. It has not been challenged by the management, my lord.
The final report, my lord, was not produced before the single judge, my lord. For that reason, my lord, the single judge comes to the conclusion that 29/3/2019, which the report was given by the medical board, is considered that he has no disability. That has been recorded, my lord, and the respondent number 1 has not participated before the single judge at all. Page 15, my lord, page 15, second para, my lord.
We'll take up one. Third of April.
Publish.
36 is urgent. Number 37. Mr. Jagdish BN.
You're for respondent number 1 in this case.
I have to take up respondent number 2 minutes.
It's a delay of 152 days.
Delay 162 days.
152 days, my lord.
It can be condoned.
That's
To be condoned.
My lords, I file objections to the same. my lord.
Objection, file it. 16th June.
Obliged.
Serial number 40.
Yes, from this side, yes.
Sir.
Sir. Yes, mister, yes. Yes, madam. Nobody?
Serial sir. ಆ ಕಡೆಯಿಂದ ಬರ್ಬೇಕು